Lord's non-commercial list.
Hmm.
This is that matter which came up as GA1 along with the presentation of plaintiff yesterday.
Non-commercial list?
Item number 42, new
Ah.
motion.
Ah.
Now, it has gone down. I'm moving it ex parte. It's a defamation suit. Every hour, the posts are being given on the LinkedIn and Facebook. Now, my entire, I'm Aditya Vikram Birla. My entire business is getting stopped because of the posts. Kindly takes up 10 minutes anytime today. Anytime, 10 minutes. Melody is having 2 p.m. fixed matter. We'll come back at 2:50, 2:55.
All matters fixed today.
No,
all fixed matters are there.
5 minutes. If I'm Millard, if I'm
3 p.m. my appellate side is there.
Give me 2:55. Give me 2:55, 2:50.
I will give you, but what about the dictation and the order, the interim order?
Passes Millard, will go back satisfactory that Millard passed. Then I'll wait for that. What is happening if I have to wait for next Wednesday? Millard, my entire suit will become Millard infractuous. I filed on 24th, moved your lordship yesterday, Millard. Okay. It was so urgent that GO1 was published along with the CS. Millard, kindly keeps it any Millard 5 minutes, Millard, any time. Anytime.
I don't know what time it will be.
2:55, 2:50, anytime. Millard, 5 minutes, Millard, in expert, Millard, I need not say much more. If I have to say, Millard, I will not give any order. 5 minutes, 10 minutes, anytime.
Only issues focus.
Millard, every hour.
2 minutes.
Millard, yesterday, Millard, I finished rejoinder within 2 minutes. Millard, in that matter. Other side got surprised that how can I finish rejoinder within 2 minutes? Anytime.
2 बजे क्या है? Come at 2:45.
Obliged.
Yes.
My lord, taking advantage of a mentioning notice that we have received, my lord, in respect of, my lord, this application GA4, my lord had granted us, my lord, time till 2 weeks for filing my affidavit in opposition. My lord, the time expired, my lord, last Thursday. It is almost ready. Next week, Monday is a holiday. Otherwise, I would have filed it by Monday. On Tuesday, I'll be filing it, my lord. Well, we have received the mentioning notice from the applicant, defendant number 10, stating that it should be taken as unopposed motion because I have failed to file my affidavit in opposition.
Who is there?
My lord, defendant number 10, my lord, Mr. Shubrodal Chaudhary is the advocate.
Mention, no.
No, my lord, I'm mentioning the matter, my lord. I'll be praying, my lord, for extension till Tuesday. I would have done it by Monday. Monday is a
holiday. That side is not here.
Well, they had only given us.
Have you served the copy?
Well, they had given us a copy of the mentioning notice.
No, that's correct. But your affidavit copy has not been served to them.
Well, that
affidavit in opposition.
Opposition.
Then they will find. They have to file the reply.
Reply. Matter is on 29th of April, already fixed. My lord, it will be by Tuesday. By Monday, I would have done it. Monday is a holiday. That's why, my lord, Tuesday it will be served, affirmed and served on the other side. 29th April matter is fixed.
29th
April the matter is fixed for hearing. 2 p.m. It has been fixed on 29th April 2 p.m. Tuesday, my lord, it's
but
only
other side is not here. How I can pass an order?
Well, let me keep it as to be mentioned, my lord. I'll give them notice.
Non-commercial.
Non-commercial.
So tomorrow it cannot be taken. It will not be taken.
My lord keeps it to be mentioned on Wednesday, my lord. By Tuesday, I'll serve it.
Wednesday.
My lord, may I be
Grateful,
permitted to mention one non-commercial matter, my lord? I am for the plaintiff, my lord. The defendant has filed his written statement, my lord. I am praying, my lord, the matter if can be listed, my lord, for necessary direction for discovery, inspection, and other formalities, my lord.
It is not listed.
It is not listed, my lord.
In the monthly list, my lord.
It is in monthly list, my lord.
What you want? Direction for inspection?
Yes, my lord. Inspection and other formalities
to be mentioned on your.
Concerning for habilitation.
For what?
Testamentary matter.
Testamentary, give the to my court officer.
To mention, my lord, as a probate proceeding, my lord, for inclusion in the list.
Give all
this. Item number 48 of today's list, my lord. It is fixed for witness action. My lord, I have taken out an application.
48?
48, my lord.
48 of the non-commercial.
Non-commercial, my lord. My lord, it's fixed for witness action. My lord, I have taken out an application as per my lord's last order to file my written statement. My lord, it is affirmed. My lord, that application.
Today's witness action.
My lord.
So,
my lord, what I am beseeching your lordship, may that application be taken out with that.
Come at 2. Let us see. Come at 2.
My lord.
Well, may I have a lordship's kind, my lord, to mention a suit where I am the plaintiff. My lord, the defendants were not appearing even after my lord, service of writ of summons. We prayed before your lordship for substituted service. Your lordship had directed publication in Hindustan Times and Sunmark. my lord, we have been informed that Hindustan Times, my lord, is not operational in the zonal places of Calcutta. So, my lord, if it can be replaced with the Statesman. We have, my lord, received the format which is needed to be published through the department, as well as, my lord, the Hindi translation.
So-and-so appearing for the plaintiff, the matter is mentioned by the learned counsel for the plaintiff and submits that by an order dated 27th of February 2023 and 2025, this court has granted leave to the plaintiff to publish the notice of the suit in the English daily newspaper Hindustan Times and Hindi daily newspaper Sunmark. Counsel for the plaintiff submit that the Hindustan Times is not publishing in Calcutta, and as such he prays for leave to allow the plaintiff to publish the notice in the English daily newspaper in any other newspaper other than the Hindustan Times. In view of the submission made by the counsel for the plaintiff is directed to publish the notice of the suit in the English daily newspaper.
The Statesman.
The Statesman. Statement is
Yes, it
circulating.
is circulating. Yes.
How much copies?
No, Statesman is there, my lord, and Times of India is also there, but Times of India is quite expensive, my lord.
In the statements in English and Sunmark in Hindi within 2 weeks from date.
I'm deeply obliged.
My lord, may I be permitted to mention, my lord?
This order, huh? Other than the Hindustan Times.
My lord, may I be permitted to,
Other than instead of Hindustan Times. Correct?
my lord, may I be permitted to mention? My lord, there was direction for issuance of citation and the necessary steps were taken by us. But the package came returned saying addressee not, and that the addressee is not found. And in the second address, it was cited as not residing.
So what you want?
My lord, discharge of the caveat by the caveator.
Caveat, have you filed an application?
Yes, my lord.
So it is listed.
No, my lord, for inclusion in the
Written.
list. Grateful, my lord.
Yes, call the list.
Looking at my instance, this is the matter where there's an injunction in respect of a public charitable trust. There are multiple applications that have been filed. Your Lordship will have a look at my Lord's order of March 19, 2025. My Lord, the only thing I'm praying today is two things, my Lord. One is that Lordship will allow me to pay out of my own pocket, whether I claim that from a trust and all, if I have to claim it in the suit, whatever I'll do. Whether the injunction restraining me from discharging any function as or claiming myself to be a trustee. So if I go ahead and do anything, I'll be in contempt of court. There's already an application for contempt pending. To pay for the Purohit there. And also there's a Hanuman Puja, Jayanti, on 12th of April. Not I will pay out of my own pocket and do these pujas. This liberty your Lordship will grant me. And to pay for the Purohit there. Otherwise, the employees I'm not being able to pay at all. These two aspects your Lordship will consider and allow me to do. I'll pay out of my own pocket and do it. And one other aspect, you know, there is an education institute that is to be inaugurated on the 12th of April. This is in the name of my mother and father. The work is not going to start. Just the inauguration will happen on that day. That inauguration, your Lordship will allow me to do. These three things, your Lordship will allow me to do, my Lord. The first two are of crucial importance because this 12th April Hanuman Jayanti, the puja that happened, this I'm told has been going on for a very, very long period of time. Well, since inception of the trust, I have gone through the balance sheet yesterday. There are two aspects which I can, we file the application, the primary contribution towards the trust has been mine. All donations that the trust has received have actually been accumulated from me. Well, the injunction that this plaintiff has obtained is primarily on the solitary ground that the minutes are dated October and the removal or his resignation letter is of November. So there is an apparent discrepancy. Look, this is evidently a typographical error. I'll be able to show because the date, this meeting that has happened somewhere in Nagpur, no?
Rajasthan?
Somewhere in Rajasthan, Ratangarh. In Ratangarh, and I was actually in Ratangarh only in November. In October, the date that is mentioned in the minutes, days when I'm having correspondence with this plaintiff. So I could not have been there. I'm going to disclose by way of a supplementary affidavit, my live location. The fact that I went there only in November. And the suit itself is not maintainable because it's a section 92 suit which has been instituted by one person. But all these facts should have been indicated to your lordship. To the first day ex parte ad interim injunction he is obtained, he challenges his removal as a trustee. And he gets an injunction that I will not be able to operate as a trustee. And then what he does is, so basically he gets an injunction that he will become a trustee.
But you have sent all the notice to the bank for changing of the signatory and all
Well,
this
that's
thing.
because he has resigned by way of 2 letters in
Correct.
November. Your
Correct.
lordship will test it.
But
Well, now what is happening is using the fact that I am restrained to claiming myself as a trustee. He has gone ahead and changed the income tax password and everything. Today, he has taken complete control of the trust. So one plaintiff comes up and seeks an injunction in respect of his resignation, and he ousts me from the trust. His press C, technically, my lord, these things I'll have to highlight before your lordship. Technically, on the first day, his suit gets decreed. He gets an injunction where his resignation is, there's a stay. I am restrained from taking any steps on holding myself as a trustee.
Correct.
But all this is coming up on the 12th of April. These 2 aspects, your lordship, will allow me to do and records my undertaking that I will do this out of my own pocket and I will not claim this from the trust. As of now, this is not going to be paid from the trust fund.
If you're doing from your own fund, why the court order is required?
But because they've already taken out a contempt.
Maybe.
Then your lordship will clarify that if I do this out of my own fund, then there is not a problem.
Why? Only the court is concerned with the trust fund.
Well,
If they file the contempt application also, they have to prove that you have misutilized the trust fund. If you are utilizing your own fund, how they can prove the fund?
No, not just the fund. There is an injunction restraining me
Correct.
from holding myself as a trustee in respect of this trust. So the moment I go ahead and make these payments, then they're going to come and say, look, I'm making, whether I'm using the trust fund or not. They're going to come and see, kindly have a look at prayer E of GA1. On the first day, ex parte ad interim, they obtain 5 injunctions. They obtain an injunction that their resignation letter will not be given effect to.
In any manner dealing with the property.
That is one. Kindly have a look at prayer E.
That's a E, dealing with the property.
Interfering with the management of the trust.
Correct.
Or in any manner dealing with any of the assets of the trust.
Correct.
So the moment I go ahead and make payment of all these employees, this is really to obviate any contempt that I may face.
Yes,
so
sir.
I thought it was only prudent to mention.
I'll tell you. Injunction has been, order of injunction on 9th of January. They've been in knowledge of this order from 10th or 11th of January. Till date, there is no appeal. There is no application for vacating.
Vacating is there.
Vacating has come after 2 months. Now, my lord, on this prayer was made when the matter last appeared on 19th March. Kindly see paragraph 6 of your lordship's order and then paragraph 8. Paragraph 8 and 9. Sorry, paragraph 8.
Last sentence.
Last sentence. So, if on this prayer was refused on the 19th of March 2025. Your lordship has said that these can be considered only after exchange of affidavits. Number 1. Now, my lord, this is a litigant, and I'll tell your lordship why he is so squirmy. After the order has been served on him, he has filed returns with the income tax, amended income tax returns, acted as a trustee, interfered with the affairs of the trust in spite of the order of injunction. Now, my lord, he can't come and seek any indulgence from your lordship. Number 1. There's a second very technical point that I usually don't like to take. Writ of summons in the suit have been served. Time for entering appearance is gone. There is no wakalatnama. I have a certificate, my lord.
Yes.
On behalf of the defendant. I'll show you. I'm not finished. Thirdly, my lord, today he says he will spend out of his funds. The question is, in spite of the order of injunction, Hanuman Jayanti is a family event that everybody is entitled to attend. I have asked for a receiver. He wants the Hanuman Jayanti to be held. Let there be a receiver. Let the expenses be made by the receiver. Let the plaintiff and the defendant jointly reimburse the receiver of the expenses. Let it happen under the order of a receiver. Let my learned friend consent to a receiver.
I'll just indicate. This is the ploy
And
that they want.
just a minute, just 1 minute. Secondly, so far as the inauguration of the educational institute, your lordship will find we had on the first occasion, your lordship's order records, we had shown a unilateral agreement signed by this gentleman with one Kashmiri Lal, which agreement your lordship has given, has injuncted from being given effect to. And he wants that the injunction should be modified by permitting him to be inaugurated. A gentleman claiming to be a trustee does unilateral acts, manufactures a forged resignation letter, removes me, now comes up with an affidavit, and we'll show your lordship. He has, after notice of the suit, created documents appointing his son backdated, removing the other trustee. He has just manipulated trust without any iota of reverence for the court.
So now who is dealing with the accounts?
Nobody is dealing with the accounts. The accounts are just there. I have not drawn a single check on the account of the trust.
May I just respond to this? Lord, his suit is that his resignation that he has made is a forged or a manufactured document. He comes and invokes section 92 because of the public charitable trust. Your lordship will just have a look at the cause title. There is one plaintiff. Lord, this ought to have been pointed out to the court that section 92 is a mandatory provision. One person cannot, and it's not a curable defect. The moment I take out the moment I take out a demurrer application, he files an amendment to bring in a second trustee. Now, the cause of action is that I have taken the minutes is dated October, the resignation is November. Look, today, whatever, there is an injunction. There is an injunction in respect of prayers A, B, C, D, and E and G. If your lordship compares it to the suit, it's primarily his entire suit which gets decreed except for accounts. So it is true that from January, there is no appeal that is preferred. It is also true that I did not come and file a vacating in probably 1.5 months. Today, what is happening is this entire trust, in respect of which there's a resignation, has come to a complete standstill. I am only saying that your lordship has fixed and correctly all these applications on 12th of April, on the 10th of April. This puja is supposed to be held on 12th of April. It is only going to augur to the benefit of this plaintiff if a receiver is appointed, which is one of the harshest remedies in civil law. To have a receiver appointed over a public charitable trust, he is not made out a case because that case has to be of a highest degree. Because somebody else comes and takes control in Ratangara of a trust, which he has letters which have disclosed. He is writing to me saying, please manage it, I am not interested. Well, the dispute is a different dispute with regard to a family. He tries to therefore get out of the trust. That letter we've disclosed, and I'll show that letter, where before this he's writing to me saying, I don't want to continue, I don't want to get into the management of the trust, you do it. The entire contribution in the management of the trust has been mine. All I'm saying is, for this puja, please allow me to make expense from my pocket and to hold this puja and to pay the pujaris and the employees of... It is true that this has paragraph 8, your lordship records.
Instead of you, that's why a special officer cannot be appointed to hold the puja and whatever it may be, and to pay the remuneration of the employees till the application is disposed.
No, the moment your lordship appoints
not the receiver, a special officer will take care of.
Even with a special officer, that's his prayer in that other GA, to which we have an affidavit. We filed an affidavit, to which I have an affidavit. Your lordship will consider it. This is just one solitary puja. I am not using the trust fund. To get out of this difficulty, I am mentioning the matter there because they want this receiver so far as the trust fund is concerned.
No, I am saying
this is not even management of the trust.
So this is the trust, correct?
Yes,
you have to celebrate the Hanuman Jayanti on 12th of April, whatever it may be. With regard to the inauguration, I am not satisfied. With regard to the Hanuman Jayanti, okay, I will appoint a special officer. A special officer will allow to spend the money with regard to, and both the party
kindly not do that. Kindly not do that, because the moment a special officer is appointed, then payments and all go out of the trust. Appointing a special officer on a public charitable trust, the degree is the highest, which is why we filed an affidavit. Your lordship has not allowed it on the first day. Now, on my mentioning, he can't have a special officer appointed. He has filed that application,
means
your lordship has
the
rejected
application will be
affidavit, that
taken up on
affidavit
the
is coming up on the
Or
10th.
you are mentioning it is
But
not.
my
you-
mentioning is
you are
only
mentioning,
restricted
you
for your
are
lordship.
mentioning the matter for the modification of the order.
No, for
the
your lordship's
modification, you
kind
have given the
consideration,
suggestion.
not even
But the-
modification. My lord,
No.
I am not saying that this order, what has just fallen from this honorable court, that I could have actually gone ahead and done this without troubling your lordship. Because this is out of my own funds. I am not using the trust fund. This is also not really interfering with the management of the trust. But I thought it was prudent as your lordship's officer to come and indicate this to the court. Because I am indicating it to the court, my learned friend can't have a special officer appointed over the management of the trust. That's a separate application. Well, if your lordship is not with me on this, then I am not praying for that relief. But my suggestion to my client was that since the court is in CSN of it, whether you're paying it out of your own funds or not, at least indicate it to the court that you want to do this. This is money that is going to come out of my pocket. This has been going on since the inception of the funds. There is no of the trust. There is no restraint on my learned friend to come and participate. That is not a problem. Out of my pocket, I will give it. The trust fund is also not there. And what my learned friend does, the moment he comes and gets this injunction, he takes complete control of the trust. The income tax, password, the ID, everything is changed.
There is no liberty given in the order.
And there is no liberty given in the order for him to do all this. Lord, kindly considers this. Somebody comes and approaches the court saying from the trust, my removal is fraudulent. And he comes and obtains an order saying his removal is stayed. I am removed because prayer, if your lordship will find that I am restrained from interfering accounts, I can understand. Because he can still have a valid concern that because he is removed, I am in control. I am trying to utilize the funds. Now, just to get out of that, I am saying out of my own funds, I will claim it. And your lordship will record my undertaking that this expense I will not claim from the trust. But for a trust in which I have been in management of from the beginning, the entire capital contribution is mine. My capital contribution is close to 20 lakhs.
Yes.
His capital contribution is 3.5 lakhs. The balance sheet records that.
Yes.
I'm not even utilizing this much your lordship will allow me to do. And then test my vacating, whether the suit is at all maintainable. Well, this is also a party's duty to come and indicate when he approaches the court. Because it is not for the court to look into all this.
Yes.
Which is why suppression is a ground to seek a vacating of an order. Suit for a public charitable institute trust can't be made by one plaintiff.
Okay. That's
The
all.
inception is incorrect. So at least this much your lordship will give me, Mullah, to hold the puja out of my own funds with the recording that I will not claim this fund from the trust.
Yes. Yes.
But my submission would be that the puja should be held. There is no doubt about that. Let it be held out of the trust funds itself under the supervision of a special officer. So that there is no allegation at a later stage that somebody has spent more, somebody has spent less.
Which application you filed for the special officer?
But your lordship will not pass an order on the special officer. Mullah.
Which application I'm asking? Is there any application?
Yes, yes, GA2.
Yes, there is an application.
GA2. I have asked for receiver on the basis that after the order of injunction, he has still violated that order.
Well, kindly, if your lordship is considering appointing a special officer, then I'm withdrawing my request by mentioning.
Suffering for the plaintiff.
Well, the special officer appointing over.
Suffering for the defendants. The matter is listed as to be mentioned on the prayer made by the counsel for the defendants. Counsel for the defendants submitted due to the interim order passed by this court dated 9th of January 2025, the defendants are not in a position to pay the salary of the employees of the trust as well as the salary of the Purohit of the. There is a temple.
There is a temple. There is a temple.
Purohit of the temple. And as such, the defendants are facing great difficulties. The counsel for the defendants further submit that there is a Hanuman Jayanti on 12th of April 2025, which celebrates in each year, and as a due to each year, but due to the injunction passed by this court, the defendants are not in a position to celebrate the Hanuman Jayanti. He submits that the defendant is all defendants.
Defendant number one.
The other defendants are the banks, my lord, and
Bank.
the other
The
trustees.
defendant number 1
Yes.
is ready to spend the total expenditure to celebrate the Hanuman Jayanti, which is to be Hanuman Jayanti on 12th of April 2025 from his own pocket, and he will not claim any expenditure incurred for the said festive set puja on 12th from the trust fund. Full stop. So per contra, learned counsel for the plaintiff submit that the similar submit that on 19th March 2025, the defendant has made a prayer for modification of the order with respect of the payment of salary of the employees of the trust, but this court has not passed any order with regard to the same. Now the defendant, full stop. The counsel for the plaintiff further submit that if the defendants are interested to celebrate the Hanuman Jayanti, that the plaintiff will not stand in the way, but a special officer can be appointed so that the special officer can, so that on the supervision of the special officer, the Hanuman Jayanti can be celebrated on 12th of April 2025. So, learned counsel for the defendant number 1 raised objection and submitted that that the plaintiff has already filed an application being GA2 of 2025 for appointment of receiver, and at this stage a special officer or receiver is appointed, it will amounts to allowing the prayer made in GA2 of 2025. Heard the learned counsel for the respective parties, this court find that it is not disputed that the plaintiff and the defendants were celebrating Hanuman Jayanti every year, and this year the Hanuman Jayanti is falling on 12th of April 2025. The defendant voluntarily came before this court and submitted that he will spend the expenditure for the celebration of the Hanuman Jayanti on 12th of April 2025, and he will not claim any amount from the trust fund for the expenditure of the Hanuman Jayanti. Considering the same, this court allowed the defendant number 1 to celebrate the Hanuman Jayanti on 12th of April 2025 by spending his own expenditure as undertaken by the learned counsel appear for the defendant before this court. Other than full stop. In view of the above, the order dated 9th January 2025 modified to the above extent.
Very grateful, my lord.
They should
But
not
can I
be
just
any-
one
just one
additional thing?
They should
I'll
not.
pay out of my I'll pay out of my own pocket all the salaries of these employees also.
That,
At least the Purohit.
that then changes the entire order.
Out of my own pocket.
No,
the
no, kindly do not
Purohit
allow
will-
that, my lord. Kindly do not
I
allow
will
that.
not claim it from the trust fund.
Then,
The
my lord, the
Purohit I will
entire-
pay for.
Cannot be that.
Purohit will not do the puja, my lord. He will not do it. I will pay out of my pocket. Purohit, the running mandir is there.
The allegation is that the
Though by an order dated 19th March 2025, this court has not allowed the defendant to pay the monthly salary of the employee of the trust by modifying the order dated 9th June 2025. But the learned counsel for the defendant submitted he will pay the remuneration, he pay the salary of the employees of the trust as well as the Purohit of his own fund. Considering the submission made by the counsel for the defendant, this court allow the defendant to pay for the present to pay the salary of the employee as well as the priest of the trust by the defendant number 1 on its own fund and to keep the proper account, and the same will be adjusted at the time of hearing of
I'm very,
My lord,
very
there is a dispute with regard to
very,
the
very
employee.
That's why keep the account and
Yes.
that will be decided at the time of
I'm
hearing.
very grateful. Lordship is very kind. Very grateful.
Milord, I am appearing on behalf of the plaintiff in a suit for eviction, Milord.
And I appear for
Okay.
the defendant, my lord. There were
Yes.
directions for discovery and inspection.
Yes.
Milord,
Milord, that direction we have not been able to comply because of some difficulties, my lord. However, the issues, my lord, are ready.
But discovery is not completed.
Yes,
How
that
the
is the
issue can be?
difficulty.
I'll tell you, Lordship, I need certain documents certified by my banker under the Bankers Book of Evidence Act before I can file the affidavit. But that has not come from my bank. I'm humbly requesting kindly extend the period by 2 weeks
Yes, my lord. I'm
for
also
completing
making
the
same
discovery and
request, my lord.
inspection.
Sense suffering for the plaintiff, sense suffering for the defendant. Though the matter is fixed today for framing of issues, but the learned counsel for the parties submit that the discovery and inspection of the documents have not been completed. Accordingly, both the parties press for extension of time. In view of the submission made by the counsel for the respective parties, time to comply with, with the order dated 20th February 2025 is extended for a further period of 3 weeks.
3 weeks.
3 weeks from date. List the matter on 22nd of April 2025 for framing of
Yes, 22nd of April. It went down perhaps as February.
22nd of April.
Tipla.
My lord, I appear for the respondent number 2 in this petition.
I appear for the respondent.
So here, my lord, we are alleging contempt of my lord's order.
Yeah. Here I appear, my lord, on behalf of the contender number 1. My advocate, Mr. Shengupta, is there, my lord.
This is with regard to a defamation suit, my lord, which has a long history. It was filed in 2017 with regard to certain articles published by the defendant number 1 in newspapers, where there are certain defamatory statements have been made against my client, my lord. What has happened, my lord? My client is a businessman. The defendant number 1 is a managing trustee of a charitable organization called Anandalok. They approached us for a piece of land for setting up a multi-speciality hospital. Accordingly, we have given them this land, and we have not taken the market value of the land. Instead, we've charged a much lesser amount. So on that basis, we are saying that there was charity done on our part with regard to handing over the land to the defendant number 1 for setting up the multi-speciality hospital. But thereafter, there are articles published in 2017 where they say that we have not given this on charity, and in fact, it was purchased by the defendant number 1. So thereafter, the suit was filed. There were orders passed where there were directions given that no allegation pertaining to donation shall be made. But thereafter, this defendant number 1 goes on to write letters and make publications, again alleging that there is no donation and, casting aspersions upon my client, my lord. Accordingly, we filed a contempt application, which is CC number 13 of 2018. Where rule was issued upon the defendant number 1. The defendant number 1 was personally present, and he tendered an unconditional apology saying that he will not make any further publications. Thereafter, they go on to make more publications. We file another GA, in which GA, my lord, passes an order in 2022, September 27, 2022, where my lord directs the defendant number 1 that he is restrained from making any publications. But thereafter, again, my lord, he has made publications in 2023, due to which we have come up with this application. This is where it stands, my lord. Affidavits have been completed, my lord.
I will tell you the content number 3, my lord. First thing, my lord, by an order dated 8th February 2024, my lord, they were supposed to correct the cost title, my lord. They have in the content number 3, my lord, they have made the editor-in-chief as a content number 3, my lord. That should be the name of the editor, my lord. My lord, that's
not corrected.
I think it was done.
My lord, we have not been served whether we don't have the knowledge, my lord, whether it has been carried out or not, my lord.
Of the CC number 16?
Yes, my lord.
Yes, editor.
My lord, the name should be there, my lord.
Yes, name is not there. Why you not done on the last occasion?
The problem was that it was the term we had used was editor-in-chief, and there was no post for editor-in-chief. Instead, there was the post of editor.
But the person who had appeared stated that editor-in-chief is not
there. The name should be there, my lord. The name,
that
my lord,
was indicated.
Who is the editor? You are appearing for whom?
My lord, respondent number content number 3, my lord.
Then, if you are appearing for the defendant number 3 editor, so
well, the name should be there.
It did not appear. The court will see whether name is required or not. It not appear. There is no name. Not appear.
Well, I think there was a previous order where your lordship was pleased to record, my lord, that so far as content number.
If the name is not there and you are not affected, so why you are appearing? Let the court pass an order against the editor.
Let have there be the direction to incorporate the name, then they would contact, my lord.
On the last occasion, it was on.
Yes, Mr. Basu, what you are submitting?
The opposition, we have filed, my lord. My lord, as as I submitted, my lord, I appear for the contempt number 1.
Yes.
My lord, on the previous occasions also, I said, my lord, this is, my lord, a problem which cropped up between the plaintiff and the respondent number 1 with relation to, my lord, that how a land was handed over.
Correct.
Whether it was a donation or something, my lord, according to the plaintiff, my lord, selling out a property, my lord, in a lesser value. But my client is almost a 90 years old.
Yes.
Well, he runs a charitable trust. It's undisputed. Well, he runs a Anandalok hospital, which is quite famous and known, well, for the benefit of the poor people, where even, well, a bypass and pacemaker, well, is being done, well, with rupees 40,000, 50,000, with, well, highly equipped and modernized, well, equipped, machineries. And here, well, so far as my instruction is concerned, well, we did not do any contempt in derogation of your lordship's order, my lord, or to any order of the coordinate bench. It is, it is, my lord, something, my lord, which is being perpetrated, my lord, on and on, my lord, to, my lord, prejudice my client who is 90 years old, my lord, who is alone, my lord, doing, my lord, some service to the poor people. This businessman, my lord, claiming to be the plaintiff, who pretended, my lord, and publicly announced, even, my lord, at the gathering before his...
Okay. Let if the pleadings have been completed, then the court will decide on merit.
Yes,
My
Lord.
lord, my lord.
So, have you in order?
Yes,
18th December.
yes, my lord.
Kindly come to the page number 3.
My lord, 8th February, my lord.
18th December 2023. Page number 3. Second paragraph. I am reading for you. Counsel for the contender submit that he will provide the details of the editor of the Sunmark to the counsel for the petition within a week from date. Show the where is the details provided.
My lord, by an order dated 8th February, my lord, that correction, my lord, is
Show me. That's I'm asking. Where is that? Show me. 8th February.
8th February 2024, my lord.
My
lord, the
Which
editor,
line?
So we have incorporated editor.
They have incorporated editor, my lord. My humble submission, my lord,
That
the
is an
name of
action.
should be my lord, incorporated, my lord. We have served the affidavit in opposition, my lord, where we have stated the resignation, my lord.
So we've acted in terms of my lord's order.
Yes, 8th February editor has been impleted instead of.
The name of the editor should be.
That's I'm telling you, if you're not appearing for the editor, leave it.
If
If it is the choice of the petitioner whether they made it in person or they made a post. That is their choice. You cannot impose, the court cannot impose. That the court will see at the time of decision. If you are appearing for the editor, very well, you are welcome. You are not appearing for the editor, please you go. So then you cannot say. The court will decide whether the editor is a party or the by name is the party.
Being
That is the merit of the matter.
being
They are not interested to make the person in part as a contemner. So that the court will decide. If you want to continue your submission, then let the case go like this only.
Okay, my lord. My lord, I am appealing for the editor, my lord. It is my duty to inform the court, my lord. That is why I am informed.
That you argue the matter, then they will say if they are not making the party.
That is, my lord, that is okay, my lord.
So
It is my duty,
the
my
court
lord.
cannot say no, you make the party.
My lord, being my lord's officer, my lord, may I also assist your lordship, my lord, to look into order of your lordship dated February 8, 2024. I
Yes, I
believe,
have
my
gone
lord,
through.
that has also not been complied by either of the plaintiff or the other contenders. I do not know, but I leave it upon them because nothing concerns to my client. But
No.
there was also a direction, my lord, to correct the cust title.
No, they have corrected. I don't need corrected copy has not been served to them.
That has not been served.
You could have been served.
My lord, that is a difficult.
That is the original copy of corrected editor. You
Change, my lord.
serve the copy
Very well, my lord. We'll do that.
My lord, this is the affidavit in
They have filed
opposition, my lord. Filed the opposition.
of CC 16
16, my lord.
of the editor or by name.
My lord, editor, my lord. My lord,
And these are our affidavit and replies, my lord.
Mr. Basu, you are completed.
Yes.
my lord, we have filed an opposition and they have also.
So you are for the 3.
I
Nobody
am
is
for the
appearing for the
respondent
1.
number 2, my lord.
2.
2, my lord.
Have you filed?
I have filed the pleadings are complete, my lord.
Yes,
But
my
you are
lord.
not never appeared before the court.
I am appearing in this matter for the first time, my lord.
First time.
In this matter. Or else I have appeared before lordship.
So and so appearing for the petitioner. So and so appearing for the alleged content number 1. so appearing for the alleged content number 2 and so appearing for the alleged content number 3. Content number 3 has filed affidavit in opposition. The counsel for the petitioner has filed affidavit in reply to the affidavit in opposition filed with the content number 3. Let the same be kept with the record. Have you filed the affidavits? No.
Affidavit's been filed? It's been filed.
Full stop. It is submitted by the parties that the pleadings have been completed. The matter is to be taken up for hearing. It is fine from the record that in terms of the order passed by this court dated 8th February 2024, the petitioner has corrected the cause title with respect of the alleged content number 3 by making the editor as party instead of by deleting the editor-in-chief. But the learned counsel for the petitioner has not served the corrected copy of the contempt application to the alleged contemners. Accordingly, the petitioner directed to serve the copy of the corrected copy of the amended application to all the contemners, to the learned advocates appearing for the all contemners within a week from date. Please the matter on 25th of April for hearing of contempt application.
I'm so grateful, man.
Very well.
I'm grateful. Extremely obliged.
For the petitioner.
Yes.
My lord, I had completed my arguments yesterday. Mr. Mitra was supposed to reply. Just one. My lord, just before Mr. Mitra starts, my lord, one more thing I missed out. My lord, that your lordship will recall, I have already placed the facts. My lord, they have, my lord, executed 3 deeds in defiance of the order. That is the case made out. My lord, in prayer I and prayer J, I have also sought for, my lord, cancellation of those deeds. Rather, my lord, the court asking them to cancel those deeds, because any act done in defiance of orders of court, not only are the contemners punishable, even the acts are to be undone. Acts are to be undone. Contempt of Court Act. Lord, kindly takes, my lord, the Contempt of Courts Act once, section 22. I and J of the petition, your lordship, and kindly see section 22 once.
Yes.
Lord, kindly see, my lord, section 22. My lord, it clearly says, my lord, that, my lord, the provisions of this act shall be in addition to and not in derogation of the provisions of any other law relating to contempts of court. So, my lord, this is really a consolidating act. All the other powers available to, my lord, the Supreme Court and, my lord, the High Court being a court of record is available to your lordship. And that, my lord, may I cite one judgment which shows that, my lord, that is inherent in the court to uphold the majesty, that if an act is done in defiance of orders, not only are the, my lord, contemners, my lord, liable to be sent to prison and, my lord, and fine may be imposed, even the acts can be and should be undone to uphold the majesty of court. Lord, in that regard, may I cite, my lord? I'm relying on section 22 and, my lord, a decision.
Yes.
The decision of 2006, volume 1, Calcutta Law Times, 355. This is a division bench.
2006?
2006, volume 1, Calcutta Law Times, 355. My lord, division bench presided over by Honorable Justice. 355, presided over by Honorable Justice Ashok Kumar Ganguly. My lord. May I just hand over the, my lord, electronic version, my lord? I'll supply a copy, my lord. Lord, here, my lord, despite an order of status quo, a post was created by an officer in defiance of the order. My lord, kindly come to paragraph 21, just the facts before I take your lordship through the law that has been laid down. Paragraph 20. My lord has found paragraph 21.
Yes.
In the contempt petition, the main grievance are that after the order of status quo was passed by this court at 12:30 p.m. on 5th August 2003, the alleged contender number 1, with full knowledge and notice of the order, issued an order in favor of the alleged contender numbers 1 and 2 at about 5 p.m. on 5th of August 2003, and as such, the order of promotion was passed in willful violation of the interim order of status quo dated 5th August 2000, same day. It is stated in paragraph 26 of the contempt petition that the said order of promotion was passed to overreach this honorable court. That is the facts exactly same. My lord, I say, my lord, undertaking given, orders passed. Then also you did not stop the process of registration. Now, my lord, kindly come to the law laid down at, my lord, paragraph, my lord, 60, my lord. I'm sorry, my lord, paragraph 57, my lord. All the English decisions have been quoted. Lord, may I just give you, lordship, the background? My lord, all the orders that your lordship will find, judgments that, my lord, we generally cite at the bar regarding, my lord, setting aside a wrong that has been done in a contempt jurisdiction, my lord, all are passed by the Supreme Court under Article 32 and 142. My lord, my lord, I was faced with a very tough question, my lord, by Justice Shonji Banerjee as he then was, that all these judgments are by the Supreme Court. How do you show me some law where the High Court, under its inherent power, can pass also similar orders? Lord, this is possibly the answer, my lord, and I cited that before also. Kindly see paragraph 50, my lord, 7. In Von Joel, the defendants evaded the service of notice of injunction, and in the meantime went on constructing the building in respect of which injunction was prayed for, but there was no report that extra men were employed by the defendant. Justice Kekevich granted an injunction restraining the defendant from building and also from allowing the building built after the date of notice, that is 24th May 1895, to remain, and there was a direction to pull down that part. In appeal, it was argued that the case is distinguishable from Daniel in that the defendant had no notice of injunction proceeding. He did not employ extra men, nor did he disobey an order of injunction. Overruling such contention, Lord Justice Lindley, a member of the appeal court, held that the case is within the principle upon which this court acted in Daniel versus Ferguson and upon which I always act. The court will not allow itself to be imposed upon by a proceeding of that kind. If builders will take the chance of running up a building in that way, they must take the risk of pulling it down. And to that extent, I think Justice Kakevich was perfectly justified in the view that he took, and this appeal must be dismissed with cause. Lord Justice Lopez, another member of the bench, also agreed as the building was constructed in defiance of the proceedings before the court. Lord Justice Rigby also agreed, as his lordship found, that the object of the defendant was to get a position of the advantage in the action before the court could interfere. Both these judgments were followed by the division bench of the Calcutta High Court in Israel versus Shamsher Rahman, reported in 19 Calcutta Law Journal 47. Speaking for the court, Sir Ashutosh Mukherjee laid down the principles by exercising revisional jurisdiction. That also was a case of erection of construction by an adjoining owner, and the court found that a substantial portion of the building had been erected after the defendants became aware of the institution of the suit and of the application for injunction. The High Court, in exercise of revisional jurisdiction, restored the order of injunction granted by the court of first instance and discharged the order of subordinate judge. One of the reasons for the court for doing so was the conduct of the defendant, which in substance amounts to a defiance of the authority of the court. Paragraph 65. Following the above principles in the fact situation, here a clear case of grant of injunction has been made out. It is rather late in the day to dispute the power of this court to grant injunctions in a contempt proceeding. The nature and necessity for the contempt power has been indicated above, and it is well settled that such power is inherent in every court of record of plenary jurisdiction. This is also clear from section 22, which I just now quoted. Act in addition to and not in derogation. And 66. Therefore, the said act does not exhaust the powers in contempt jurisdiction. The act, by laying down the procedure, can regulate the exercise of such power. The power of contempt to issue injunction in contempt proceedings has been recognized in Oswald's on Contempt, 3rd edition, and my lord, that treaty is also quoted. Then, my lord, paragraph 70. Following the principles discussed above, I must hold that in a fit and proper case like the present one, the court can, even without a finding of contempt in view of the difficulty in proving it, issue appropriate orders of injunction in order to implement its previous order and to prevent its flouting by any maneuver or subterfuge or by any other subtle modes of defiance which may not be willful and deliberate defiance. This is necessary in order to sustain the litigant's faith in administration of justice and also to maintain the law. The public purpose behind the contempt jurisdiction will thus be satisfied if the court keeps in mind these two concepts, which inevitably colorize of each other. The observation of that effect was made in appeal court in England. And my lord, in that case, the court held that the High Court has the jurisdiction to commit for breach of an injunction, even though injunction was ceased to have effect. The underlying principle has been set out. That is not my case, my lord. So, my lord, 73. After considering the peculiar facts of this case and the legal position discussed above, I stay by an order of injunction the operation of the order of promotion of Sri such and such, the opposite party number 2, to the post of additional chief engineer, till the pending proceeding before the state such and such. As a result thereof, Pal will step down from the post of additional chief engineer and the government will give him any other post. So his post was stopped and he had to step down. And the court clearly lays down the law that court cannot be a mute spectator. Apart from the punishments mentioned in section 12, which I told your lordship on the yesterday, my lord, these are plenary powers, and court has the power to pass mandatory injunction to set at naught the act done in defiance.
Okay.
Those are my submissions.
And then,
And may I give a copy?
yes.
My lord, if your lordship is pleased to look into the cause title, lordship will find that there are, my lord, 4 parties to this proceeding. Page 6, my lord, in fact, omitting the initial Ravi Sanai is the petitioner, Bhawarilal Sanai, Pushpa Sanai, and Yashvardhan Sanai. Now, Yashvardhan is the nephew of Ravi.
Yes.
And my lord, Bhawarilal and Pushpa, my lord, are, my lord, the father and mother of Ravi.
Of?
Ravi, the petitioner. Now, the petitioner wants, my lord, his 82 years old and, my lord, 80 years old parents to go to jail. I have no difficulty. He may want that. Now, before I proceed to, my lord, make my submissions, my lord, my clients are, all of them are here, my lord. I have told them to be here. The lady is in wheelchair, possibly. Now, I, my lord, on their behalf, or they, my lord, I would say, my lord, tender their unqualified apology, my lord, if they have committed any violation of the order, whether it is willful or not. Now, my lord, kindly come to the application which has been made. My lord, kindly come to page 19 of the application. Paragraph 27. The prayers in the plaint have been set out.
Yes.
Decree for partition by mates and bounds, declaration that the plaintiff and the defendants are entitled to properties mentioned, a decree for declaration that the plaintiff is entitled to 50% of the 75% of the sale price, etc. No perpetual injunction, be that as it may. Kindly turn the page. Paragraph 32, they speak about the petition. Now, my lord, kindly come to the petition. Once, my lord, I shall place a few parts of the petition. The injunction petition, my lord. It starts at page 39. Lord, kindly come to page 50.
Yes.
Paragraph 30, in the said circumstances, there should be a preliminary decree declaring the shares of the petitioner and the respondent number 1 in terms of paragraph 24. No further question is required to be tried. It is also necessary that an order of injunction restraining the respondent from dealing with and or disposing of and or alienating and or transferring and or encumbering and or creating any third party right or interest in respect of the assets and properties mentioned in paragraph 18A between the petitioner and the respondent number 1. Then paragraph 32, there is extreme urgency. Now, this was the petition. Now, in that, my lord, an order was passed by your lordship initially. Lord, kindly take, my lord, volume 3.
Yes.
Page 322.
Yes. 324.
322 is the first one.
Yes.
Kindly come to page 323. Counsel for the defendants on instruction from defendants submit that the defendants will not take any step for transfer of the suit property till 31st July. Then kindly turn the page, my lord, the next order, page 324. At 325, my lord, paragraph 1, 2, and 3, my lord, your lordship has recorded, my lord, the background. Then, my lord, kindly come to
331.
No, before that, my lord, kindly come to page 328.
Yes.
Paragraph 9.
Yes.
The learned counsel submits that the plaintiff recently came to know that the respondents, swayed by the ill advice of Rajesh Sanai, that is the elder brother, are preparing to transfer by way of gift to defeat the plaintiff of his legitimate rights. Now, my lord, I was wondering while reading, why gift? Why did it occur gift? It could be conveyance, it could be mortgage, it could be anything. Why gift? Unless he had knowledge of the fact. Then, my lord, kindly see paragraph 10. The learned counsel submits that the respondents are dealing with the property mentioned in paragraph 18A. Then kindly turn the page, kindly come to, my lord, paragraph 11. The learned advocate representing the defendant submit that the suit filed by the plaintiff is not maintainable under law as no cause of action arose within the jurisdiction of this court. Now, my lord, this suit is no more there, my lord, whether this order was with jurisdiction or, my lord, without jurisdiction, my lord, I am not going into that. And then, my lord, kindly come to the, finally, page 332 once. After paragraph 19 is quoted at the top, then the next paragraph just before paragraph 22. In the present case, stage of filing of written statement, well, it possibly has not reached. Yes, has not reached. Thus, this court at this stage is not in a position to decide with regard to the territorial jurisdiction. The plaintiff in the present application in paragraph 31 and 32 stated that the plaintiff came to know that the defendant number 1 with the ill advice of the defendant number 2 is preparing to transfer the property by way of gift. Very specific, my lord, your lordship, submission was made and that is recorded. On that basis, kindly come to page 333. In view, paragraph 24, in view of the above, the defendant number 1 is restrained from alienating or creating any third-party interest with respect to the properties mentioned in paragraph such and such till such and such. This was the order. First order is of 30th July. The second order is, my lord, of 31st of July. Now, my lord, kindly take the petition once. Lord, kindly come to page volume 1, page 23.
Yes.
Paragraph 39. However, the petitioner, upon making searches in the registry office on 5th August 2024, at about 11:49 a.m., has come to know that 3 deeds dated 1st August 2024 have been executed by the respondent number 1 and at his instance by the respondent number 2 in respect of these properties, which are part of paragraph 18A of the injunction application filed by the petition. In this regard, copies of download of deed details, not the deeds, from the official website of the Director of Registration and Stamp Revenue are annexed here to collectively mark with the letter. Now kindly come to page 337, volume 3.
Yes.
Three 337, 339, and 341. These are the 3 documents which have been annexed as my lord annexary. Now they have possibly relied on, my lord, kindly come to the box in the middle. Transaction, gift,
Date of registration and the
in
date of
favor of
completion.
family registered at such and such, deed number such and such, volume number such and such, date of registration 1st August 2024, and date of completion 2nd August 2020. This is, my lord, the basis of the contempt application. They say that, my lord, by registering the document, my lord, my client has, my lord, violated the orders of 30th July and 31st of July.
Correct.
Now, my lord, kindly these are the allegations against the respondents number 1 and 2. So far as the allegation against respondent number 3 is concerned, if your lordship is pleased to come to paragraph 48. My lord, at page 28 of the petition.
Yes. Yes.
The petitioner states that the respondents number 1 and 2 are completely under the control and clutches of his eldest son, namely Rajesh Sanai, and his immediate family member, namely Yashvardhan Sanai. Thus, the order passed against the respondents were also very much known or deemed to have been known to Yashvardhan Sanai. This is how, my lord, it's not that, my lord, their case is that Yashvardhan had abated, my lord, in perpetrating the contempt. That is not the case. Next, my lord, paragraph 49. Thus, he said Yashvardhan Sanai have induced the respondents number 1 and 2 to execute the said deeds despite having knowledge of the said orders are equally guilty of contempt of court under established principle. In any event, the said deeds have been executed despite the order and are to be cancelled. Now, these are the allegations. They, in support of the application, my lord, they rely on these 3 documents which show that date of registration is
1st and 2nd, yes.
1st of April and
August.
Sorry, 1st of August, I'm sorry. 1st of August and 2nd of August. Now, my lord, kindly take up the Registration Act.
I have also argued aggravated acts of contempt against respondent number 3. Supplementary affidavit I have.
No, kindly sorry, my lord.
52.
No, before that, kindly come to, my lord. I shall go to 52, but kindly before that, kindly come to 32. My lord, how registration is affected, my lord, basically. part 6 of presenting documents for registration. 32. Persons to present documents for registration, except in the cases mentioned in section 31, 88 and 89, we are not concerned. Every document to be registered under this act, whether such registration be compulsory or optional, shall be presented at the proper registration office, A, by some person executing or claiming under the same, or in the case of a copy of a decree or order, claiming under the decree or order, then B, by the representative or assignee of such a person, C, by the agent of such person, representative or assignee. We are concerned with the person. Then kindly come to section 34.
Yes.
Inquiry before registration by registering officer. Subject to the provisions contained in this act and in sections 41, 43, 45, 69, 75, 77, 88 and 89, no document shall be registered under this act unless the persons executing such document or their representatives, assigns or agents authorized as aforesaid appear before the registering officer within the time allowed for presentation under section 23, 24, 25 and 26. Provided that if owing to urgent necessity or unavoidable accident all such persons do not appear, the registrar, in case where the delay in appearing does not exceed 4 months, may direct that on payment of a fine, etc. Then 2, kindly come to 2. Appearance under subsection 1 may be simultaneous or at different times. 3. The registering officer shall thereupon inquire whether or not such document was executed by the person by whom it purports to have been executed, satisfy himself as to the identity of the person appearing before him and alleging that they have executed the document. C, in the case of any person appearing as a representative assigned, it's not required. 4, any application for a direction under the proviso to subsection 1 may be lodged with the sub-registrar, who shall forthwith forward it to the registrar to whom the subordinate. Nothing in this section apply to copies. Now kindly come to section 35. Procedure on admission and denial of execution respectively. 1A. If all the persons executing the document appear personally before the registering officer and are personally known to him, or if he be otherwise satisfied that they are the persons they represent themselves to be, and if they all admit the execution of the document, or B, if in the case of any person appearing to be by a representative, assigns or agent, such representative, assign or agent admits the execution. C, if the person executing the document is dead, kindly omit that. Then 2, kindly come to subsection 2. The registering officer may, in order to satisfy himself that the person appearing before him, I'm sorry, my lord, I missed one. Kindly come to C once. If the person executing the document is dead and his representative or assign appears before the registering officer and admits the execution, then the registering officer shall register the document as directed in section 58 and 58 to 61 inclusive. So presentation or admission, on admission. Then kindly come to subsection 2. The registering officer may, in order to satisfy himself that the persons appearing before him are the persons they represent themselves to be, or for any other purpose contemplated by this act, examine any one in his office. Then by lot 3A onwards, it's not required. Then kindly come to alert paragraph 52. Sorry, section 52, alert. Sorry.
Yes.
Duties of registering officer when document present. The day, hour, and place of presentation, and the photographs and fingerprints affixed under section 32A, and the signature of any person presenting a document for registration shall be endorsed on every such document at the time of presenting it. B, a receipt for such document shall be given by the registering officer to the person presenting the same. C, subject to the provisions contained in section 62, every document admitted to registration shall without unnecessary delay be copied in the book appropriate thereof for, and according to the order of its admission, then all such books shall be authenticated. It's not required. Now kindly come to section 58 once more.
Yes.
Particulars to be endorsed on document admitted to registration. On every document admitted to registration other than a copy of a decree or order, or a copy sent to a registering officer under section 89, there shall be endorsed from time to time the following particulars, namely the signature and addition of every person admitting the execution of the document. And if such execution has been admitted by the representative, assign, or agent of any person, the signature and addition of such representative, etc. Then B, the signature and addition of every person examined in reference. C, any payment of money.
Yes.
Now kindly come to my lord the next section, section 59.
Yes.
Endorsement to be dated and signed by the registering officer. The registering officer shall affix the date and his signature to all endorsement made under section 52 and 58 relating to the same document and made in his presence on the same day. Then kindly come to the next section, my lord, section 60.
No, the 59.
Yes.
The registering officers shall affix the date and signature of all endorsement made under section 52 and 58 relating to the same document and made its presence on the same day.
That's right.
What is the same day? When it was presented before.
Yes. When it was present. Now kindly come to 60. Certificate of registration after such of the provisions of 34, 35, 58 and 59 as apply to any document presented for registration have been completed with, the registering officer shall endorse thereon a certificate containing the word registered after compliance of everything. Together with the number and page of the book on invoice and such, etc. Now, my lord, kindly take the affidavit of the respondent number 1. My lord, affidavit affirmed by Banwarilal Sanai on 28th August 2024.
Yes.
Kindly come to, I do not want to place the affidavit, my lord, kindly come to page 96. The documents.
Yes.
Kindly see, it is dated 18 July 2024. Kindly turn the page. Kindly see in the middle, Lordship will find the seal of the office of the district sub-registrar 3, the round seal, page 97, my lord. Lordship got that. Then, my lord, Lordship will find, my lord, just below that, there is a rectangular seal of the registrar, 18 July. My lord, this continues on the reverse of each and every page. I do not want to trouble your lordship with all those pages. Now kindly come to page 150.
One?
150, the last page, my lord, of volume 1.
Yes.
Lordship got it. Now on the left on the top, lordship will find Banawarilal Sanai, son of Dulichand, executed by self, date of execution 18 July 2024, admitted by self, date of admission 18 July. Then, my lord, I have placed before your lordship these sections, the photograph, the, my lord, left thumb impression, and, my lord, the signatures are required to be taken. Kindly see the photograph is there. Just below the photograph, kindly see the date. 18 July. Similarly, my lord, under the, my lord, left thumb impression, kindly see 18 July. Under the signature, 18 July. All those were taken on 18th of July. Then, kindly come to the next part. CT not specified, etc. Kindly omit that, my lord. Kindly come to the last line of page 150. Admitted by self, date of admission 18 July 2024, place office. Similarly, same thing, my lord, your lordship will find, so far as the donee details are concerned, same. Admitted by self, date of admission 18 July. Then, my lord, the photograph, the left thumb impression, and, my lord, the signature all were taken on 18th of July. Now, kindly come to volume 2, my lord.
Yes.
Kindly come to page 152.
Yes.
At the top, lordship will find presented for registration. Presented for registration at 14:19 hours on 18 July 2024 at the office of the DSR 3 South 24 Parganas by Yashvardhan Sanai Clement. Now, my lord, I have shown your lordship the provisions of the act, my lord. It says that on the date of presentation, the date, time, and the place have to be given. Then, my lord, kindly omit the next one, certified that, kindly omit that. Then, my lord, next one. Execution is admitted on 18 July 2024 by Banawarilal Sanai, son of such and such, etc., identified by so and so. Now, this is one of the documents. So, my lord, the document was presented for registration on 18th of July. The document was executed on 18th of July. It was presented for registration on 18th of July. Much before, my lord, either of the orders was passed by your lordship.
Yes.
Next document, my lord, kindly come to. Oh, before that, my lord, kindly come to page 154.
Yes.
At the top, lordship will find certificate of registration. Certificate of registration under section 60 and rule 69. Registered in book number 1, volume number such and such. I placed section 60 before your lordship that on completion of registration, my lord, it has to be put in. And, my lord, kindly see at the bottom, when was the registration completed? On 2nd of August. So far as, my lord, after presentation of the document, my lord, my client, my lord, it's nobody's case that after presentation of the document, my client had anything to report. He could not have done it. Rest of it, on presentation, on admission, my lord, the rest of the job, my lord, was of the registering office, my lord. They would copy it or take necessary steps in terms of the acts and rules. And then finally, my lord, the certificate comes. Certificate was issued on 2nd of August. Now kindly come to the next document.
Why they have not, if they knows and submitted before this court, they will not, why they have not informed to the registration office? The advocate appeared here and stated that yes, they will not take further steps. Okay, 18 July agreed in terms of act also agreed, no problem, presented, signed, executed. They know the certificate is not issued. They could have been requested the the registration office not to execute, not to register.
Two things, my lord. I really do not know. I was looking into this, the act. I really could not look into the rules in details. I could not find out any provision where, my lord, after, my lord, the presentation of a document, the executant or anybody else, my lord, can make such request.
Can be.
There can be. There is provision to that effect.
Because why provision I have to check, because I remember thing, because if you registered, then why the register the certificate of 60? In the meantime, if any complaint received, why the register?
The registering authority can.
That's why registering authority. That's why I'm asking.
If a complaint is
complaint or any, if the party. So that's why I'm asked the put once your client made an undertaking before this court, they had the knowledge on 18 July, they have executed the deed, presented the deed, no problem.
Not only they, my lord, the petitioner also had the knowledge, and that is why on 31st of July, they submitted before your lordship that deed of gift is being executed.
No, whatever. So that
not a conveyance, not anything else. Specific
deed of gift. Yes.
Now, that was, my lord, as I said, my lord, otherwise, my lord, lordship, what fell from your lordship, otherwise, kindly, my lord, contemplate a situation. My lord, I execute a deed today, a conveyance, in favor of, my lord, Mr. X. And tomorrow I give a letter to the registering authority, then don't register. My lord, that would create, my lord, enormous difficulty. Possibly that is why, my lord, there is, my lord, no provision of the executant or anybody, my lord, connected with the execution writing such letter. Definitely, my lord, a complaint is received. My lord, registering authority, or my lord, an order is received by the registering authority is bound to do. But there has to be an order on the registering authority. There was none. And my lord, whether they could have done it or not, my lord, in my respectful submission, cannot be said to be, my lord, an
willful
disobedience. Order was don't transfer. It's not that they transferred all the properties. Gifts were in respect of, my lord, three or four properties, whatever it is. Not that all the properties were, my lord, transferred. There are other properties. Now that is in fact the subject matter of, as I said, my lord, the suit has been, my lord, it has been said that this court has no jurisdiction. They have accepted that, they have filed a suit in Alipur. Now, that is, my lord, it's nobody's case that after, my lord, the order was passed, my lord, a further transfer was made in violation of the order. And as I have submitted before your lordship, that, my lord, it in my respectful
but there is one letter, why you issued a letter for transfer in the society?
I shall come to. I shall come. All. Oh, I'm sorry, my lord. I'm told all the properties. I thought there was another property. Be that as it. Yes. Now, this letter was written, my lord, I understand, my lord. Thereafter, my lord, it was also withdrawn, and that is possibly recorded in an order passed by your lordship. Now, this is the position so far as the other documents are concerned, my lord, also. My lord, if your lordship is pleased to come to page 155.
Same, all are the same.
Same. 18 July,
All are,
sent it. My lord, admitted on 18th of July.
yes, page 81, 85.
Yes, my lord. 85, 185.
185.
Same, identical. And 188 is, my lord, the
Certificate.
time given by the registering. Similarly, my lord, 191.
Yes, these are the same thing.
Yes,
On 18 July.
Identical, I would say, subject to correction. Now, my lord, in view of this, my lord, in my full submission, so far as I said, my lord, so far as, my lord, the subsequent letter is concerned, that was withdrawn. In any event, my lord, that has not been described as an act of contempt. There was no transfer. They only say, or he only said that give the bills in my favor. And that was withdrawn in it. Now, in view of this, my lord, in my full submission, there was no, my lord, oh. My lord, there is an order of 8th of October 2024 passed by your lordship. May I hand? Yes, it's in the context. But kindly come to, well, lordship is at the 8th October order.
8th August.
No, 8th October.
Yes.
The third paragraph, my lord, the alleged contender number 3 has filed an affidavit stating that he will not take any step on the basis of the gift deed executed by the respondents number 1 and 2 in his favor till the disposal of the instant contempt application. He further undertakes that he will recall the letter dated 30th September 2024 immediately by issuing a letter to the association. Now, that was done.
Yes.
Now, my lord, to summarize, my lord, my submission, my lord, I would say, my lord, I am not citing any decision whether, my lord, willful disobedience or not, my lord. In my submission, what is full disobedience? I'm not going into that. I have, my lord, tried to demonstrate before your lordship that there was no disobedience on the part of, my lord, my clients, either of them. The order, my lord, strictly speaking, my lord, the order said that he will not transfer and nothing was done thereafter. No transfer was effected thereafter.
What is the order?
The order is, my lord, at page, kindly take, my lord, the
334.
324.
320.
Sorry.
332.
Yes. 332, 333, basically.
Restraint by alienating, creating any third party interest with respect to the properties. Yes.
It was not done. My lord, I am again saying, my lord, that I am not going into, my lord, the law content, my lord. In my respectful submission, my opinion is, my lord, the court's dignity has to be upheld. That is why, my lord, I started by saying that all of them are here, my lord, though your lordship had dispensed of with their, my lord, personal appearance, my lord, still I told them to be here. Now, they, my lord, through me, my lord, have, my lord, tendered their unqualified, my lord, apology if they have, my lord, in any manner violated the order. Again, my lord, I say I am not going into, my lord, the technicalities, whether, my lord, the order, which really, my lord, was found to be, my lord, without jurisdiction, my lord, a contempt.
No, no, no. After they did, whether any transfer?
No, no. It's nobody's case.
Yes.
My lord, those are my responses.
Thank you.
Oh, I'm sorry. Sorry. Yes. The two judgments, yes. Vitally important. Vitally important. বয়স হচ্ছে তো ভুলে যাই। না বাবা তুমি irrelevant judgment দেখাবে। My lord, two judgments have been cited before your lordship.
Yes.
The first one, my lord, kindly come to 2017 volume 1 Supreme Court cases, page 599. হ্যাঁ যাও আমার ওখানে হয়ে যাচ্ছে 16 ডিভিশন দেখছি না যা kindly come to the first paragraph.
Yes.
Contempt petition number such and such at the instance of so and so, the appellant in civil appeal number such and JK Jute Mill Mazdoor Ekta Union, the appellant in civil appeal number such and such, seek to highlight disobedience and violation of the order dated 8 May 2014 passed by this court in the said civil appeals and other connected matters. The text of the order of 8 May 2014 was to the following effect. Since it is not possible for us to take up the matter today, etc., my lord, an order of injunction was passed. Then kindly come to, my lord, paragraph 2.
Yes.
Tacitum B kindly come to, my lord. Or 5 lines from the top of paragraph 2.
It is
alleged. It is alleged in the present contempt petition that in violation of the order of 8 May 2014, which was passed during the pendency of the aforesaid appeals, the assets owned by the company, namely JK Jute Mill, at such and such, spread over 1.6 acres of land, were sold with a conveyance dated 2nd July 2014. And consequently, the persons arraigned as contemners interfered with due administration of justice. It is prayed that the contemners be punished for disobeying the order of 8th May 2014 and at the same time the conveyance dated 2nd July 2014 alienating Katihar property be declared null and void. Then kindly come to paragraph 4. There was BIFR proceeding, my lord. The proceeding of BIFR dated 7th February 2013 show that in compliance with the earlier direction, the operating agency was in the process of finalizing a draft rehabilitation scheme, and in furtherance of the directions of sale of certain assets, notices were issued. Notices were already sent to the company. Then, my lord, kindly turn the page. At the top, my lord, Placitum A. On 28 February 2013, 4 advertisements were issued in prominent newspapers by the operating agency, inviting bids for sale of the properties of the company, including Katihar property. Then kindly come to 6. When the matter was thus being considered for finalization of DRS and for sale of assets of the company in the proceeding of the BIFR dated 4th April 2013, it was submitted on behalf of the company that the net worth of the company having turned positive, BIFR no longer retains jurisdiction over the company. Then, my lord, kindly come to paragraph 7. My lord, kindly come to placitum G.
Yes.
The proceeding of BIFR dated 16th April 2013 disclosed that BIFR had observed that manipulation of accounts had been alleged against the company, and BIFR would examine the same and inquire whether the net worth of the company had turned positive or not. At this stage, various proceedings, including those at Guwahati, were instituted as detailed in the judgment of this court dated 13th November 2014. In title suit number such and such, the civil court at Kamrup, Guwahati, by an interim order dated 13th May 2013, restrained the defendant therein, including BIFR, from proceeding with reference number such and such. This order and subsequent proceedings taken up in Guwahati High Court led to the filing of special leave petitions giving rise to the aforementioned civil appeals, in which the court passed the order dated 8th May 2014. During the pendency of the aforesaid civil appeals, in this court, the aforementioned contempt petition number such and such were filed, alleging alienation of Katihar property with a conveyance deed dated 2nd July 2014, in violation of the order of 8th May 2014. Company petition number such and such was taken as the lead petition, and the basic allegation about the involvement of various contemners as detailed in paragraphs 4 and 7 to 14 in the contempt petition are in the following effect: that the contemners number 1 to 3 in conspiracy and collusion with other contemners, the particulars of which are given hereinafter, have after 8th May 2014 sold away by executing a registered conveyance deed dated 2nd July 2014 capital assets of the company, etc. Then, my lord, I am omitting paragraph 7, the set out paragraphs. Now, kindly come to page 608.
Page
608, Lordship will find at the top on the left hand corner, my lord. My lord, kindly come to placitum E. Roman 4. On 31st May 2014, contemner number 10, Deputy Collector, District Legal Branch, Katihar, made the following endorsement on the order dated 21st March 2014, passed by contemner number 9 to contemner number 11. Then 5. On coming to know of the fact that the contemners are in the process of illegally selling away the Katihar capital asset of contemner number 1 company to contemner number 14 company, being the company controlled and managed by so and so, the petitioner through its counsel wrote a letter dated 10 June 2014 to the district magistrate and collector and brought to his notice the orders passed by the Allahabad High Court and this honorable court regarding restraint order on the sale of land and property of contemner number 1 company. And kindly turn the page 6 at the top. The counsel for the petitioner also wrote another letter dated 10 June 2014 to contemner number 10 with copy endorsed to contemner number 9, 12, 13 and to the Register of Assurances District Katihar and the Chief Minister, and specifically pointed out the restraint order passed by Allahabad High Court and by this honorable court and enclosed the copy of the order. Thereafter, the counsel for the petitioner wrote a letter dated 13 June 2014 to contemner number such and such and to the Finance Minister, Chief Secretary and Assistant IG of Registration, specifically bringing to their notice that the order dated 8 May 2014 passed by this honorable court and requested that the conveyance deed in respect of the Katihar capital asset be not registered. Despite the letters dated 10 June and 13 June of the counsel for the petitioner, bringing to the notice of the contemner number 9 to 13 of the orders dated 8 May 2014 passed by this honorable court, contemners number 1 to 17 willful disobedience proceeded ahead with the process of registering the conveyance deed in respect of Katihar capital asset of contemner number 1 and by a registered conveyance deed dated 2nd July 2014 conveyed the Katihar capital asset of contemner number 1 company to contemner number 14 company, which is owned and controlled by contemners number 2 and 3 for a paltry sum of rupees such and such. Then 12. Another instance of fraud and backdating of the conveyance deed is evident from the fact that The conveyance deed is signed by one Shohanananda Jha, container number 7, as director of container number 1 company. But as on the date of the signing and or execution of the conveyance deed, he had on 17th February 2014 resigned as a director of container number 1 company. The said Shohanananda Jha long back changed his name to Ravi Shankar Prabhakar and got his name changed in the records with the Register of Companies. But he still signed the conveyance deed on behalf of the container number 1 company as a director with his name written as Shohanananda Jha. Then kindly come to 14. That the subject matter of the Cartier capital asset is part of the scheme before BIFR and in respect of the permission granted for sale of the Cartier capital asset and other assets of the container number 1 company. On an appeal being special appeal number such and such, Allahabad High Court by order dated such and such, past direction, etc. Kindly omit that. Kindly come to page 611.
Yes.
My lord, 13. Pursuant to such notices, the alleged contemners filed their responses as under. In his reply, which was also on behalf of the company, Sri Shoshikant Jha, director, submitted that Katihar property was sold and transferred to the alleged contemner number 14 on 4th April 2013 for consideration of rupees 3.55 crores long before the filing of the matter in this court and passing of the order dated 8th May 2014. It was submitted that the entire consideration was received by the company on 4th April 2013 by check and constructive possession was also handed over. Then kindly turn the page. Sorry. May I, my lord, continue there. And constructive possession was also handed over to the purchaser on 16th April 2013. The reply further stated, the deed was presented for registration before the registrar on 16th April 2014. As per the Revenue Department, the stamp duty payable was higher than, my lord, it should be 16th April 2013. Possibly there is a mistake. Page 612.
16 February, yes.
16th April 2013. It should be 16th April 2013.
16th April 2013.
Yes. The deed was presented for registration before the registrar on 16th April 2013. As per the Revenue Department, the stamp duty payable was higher than affixed, and accordingly the matter was pending adjudication. It is only thereafter that this Honorable Court had passed the interim order dated 8th May 2014, restraining the company from disposing of capital assets of the company without taking permission from the Honorable Court. By this time, the property in question had for all practical purposes already been transferred. Only the ministerial act of actual registration by the authority concerned was remaining, which also was being pursued by the purchaser. It is submitted that VDA board resolution dated 6 February 2013, an authority had been given by the company to the alleged contemner number 7 herein to sign and execute the sale deed. Subsequently, alleged contemner number 7 had resigned from the directorship of the company. The alleged contemner number 7 was called upon by the purchaser for getting the sale deed registered. Therefore, there was no willful or deliberate violation of the interim order dated such and such. I pause here for a moment. Stamp duty was outstanding. Until and unless the stamp duty was paid, my lord, the document could not have been registered. So there was an act on the part of, my lord, the alleged contemners, my lord, in violation of the order. Then, my lord, kindly come to 13.3. In his reply, the alleged contemner number 6, Rakesh Singhania, etc. Then, my lord, last two lines. Alleged contemner number 7, Shohunlal Jha, the person who executed the document. My lord. Alleged contemner 7, Shohunlal Jha, who had executed the deed on behalf of the company, submitted. My lord, kindly come, my lord, I am omitting. Kindly come to the last two lines of that page.
16th April 9.
Yes. The standoff, my lord, contemner number 7, the person who executed or signed the document. The deed was presented for registration by the buyer on 16th April 2013. But as stamp duty as assessed by the revenue authority was on the higher side, the registration of the deed did not take place. The buyer, after certain correspondence with revenue authorities, was able to reduce the value of stamp duty payable on such registration. As a considerable time of more than 1 year had elapsed, the buyer had contacted the answering respondent to get a fresh deed executed and to get the same registered.
Leaving aside the other one.
Yes. This is, my lord, the document.
Yes.
As the answering respondent had been given the authority which was not revoked till then, the answering respondent on good faith executed the fresh sale deed which was presented for registration and was finally registered on 2nd July 2014. Subsequent event. Then kindly come to, my lord, kindly come to 13.4.
Yes.
Or before that, my lord, kindly come to C. Sorry. Class item C. In his supplementary affidavit, Shovanand Jha further submitted 1. That on 2nd July 2014, at the time of registration of the conveyance deed, I had produced the authorization being board resolution of 6 February 2013 given in my favor by the board of J.K. Jute. That although the sale deed of 2014 mentions my designation as director, it is a typographical error and which has been carried forward from the earlier sale deed of April 2013. And nothing more. It was not my intention to show myself as director of J.K. Jute Mill at the time of registration, as I had resigned from the board of directors in February 2014. The only authorization in my favor was the one mentioned in para 1. Now kindly come to 13.4. Alleged contender number 10, Mohammed so-and-so, Senior Deputy Collector Goa, submitted that soon after receipt of the letter dated 10 June 2014 sent by the counsel for the appellant along with copy of order dated 8 May 2014 passed by this court, he had ensured that the same was sent to the sub-registrar concerned to take necessary action as per rules vide letter dated 26 June 2014. However, despite such letter, the sale deed was registered on 2nd July 2014, whereafter charges were framed against the district sub-registrar Katihar and the circle officer Katihar for disobeying the order passed by this court on 8 May 2014. In his reply, alleged contender number 11, Sanjay so-and-so, district sub-registrar Katihar, submitted that he was not a party to the proceeding before the court, etc. My lord, kindly turn the page. Kindly come to 13.5. In their common reply, alleged contemners number 14 and 17 submitted that the transfer under the document dated 2nd July 2014 was a bona fide purchase for consideration that the property was already in the possession of the transferee under a long-term lease and that the transferee had no knowledge about the order of 8th May 2014. Then kindly come to paragraph 14, my lord, class item D.
Yeah.
It was submitted that he, being privy to the proceedings before BIFR and being aware of the order of 8th May 2014, ought not to have registered the document. In his subsequent affidavit dated 27 January 2016, alleged contender number 17 submitted that he directly worked under the alleged contemners number 2 and 3 and that he used to sign documents.
Yes.
Then, my lord, kindly come to paragraph 17 directly, my lord. The first question that arises is whether any alienation or transfer was effected after the order of 8th May 2014. The submission of the alleged contemners is that the conveyance deed was executed on 4th April 2013, on which date the entire consideration stood paid by the transferee and was credited to the account of the company, and as such the title passed in favor of the transferee well before order of 8th May 2014. And what was done on 2nd July 2014 was a mere ministerial act. According to the alleged contemner, the document presented for registration in April 2013 were not accepted for want of adequate stamp and registration fees. This infirmity was removed, and the documents were then presented for registration. In such circumstances, the order of 8th May 2014 was not in any way violated. This is the stand. The infirmity was removed after the order, then presented for registration.
By that time, order was there.
By that time, the order was there. Then, my lord, kindly come to paragraph 18.
18, they have relied upon.
They have, my lord. The order of 8th May 2014 had directed that capital asset of the company shall not be disposed of without taking permission of this court. The expression shall not be disposed in the context connotes action or process of sale of asset. Going by section 54 of the Transfer of Property Act, transfer of any tangible immovable property of value of rupees 100 and upwards can be made only by a registered instrument. The expression only in this section is significant. The transfer comes into effect and becomes valid and effective only by a registered instrument. It is true that the document was sought to be registered in April 2013, but the registration in question was duly effected only on 2nd July, when, my lord, the stamp duty was paid.
Correct.
In the eye of law, it is this document registered on 2nd July which alone effectuates transfer of interest in Cartier property in favor of the transferee. The transfer was thus effected on 2nd of July 2014, that is well after the order of 8th May 2014, in Suraj versus such and such, etc. Then kindly come to paragraph 19. The document dated 4th April 2013 did not by itself create any interest, nor did the title pass upon execution of such document on 4th April 2013, but it was only after the registration on 2nd July 2014. As I have submitted, my lord. If the document, there was no, my lord, infirmity in the document, if the document was presented for registration and the registering authority completed the registration, my lord, this situation would have been different.
So that's why Mr. Ghosh has stated that here also what you subject to, as per their submission, it was presented, they had the knowledge. In the meantime, the order was passed. They have taken the date of 1st of August and 2nd of August. The registration. They are taking the date of registration on 1st of August.
Now, as I have submitted, my lord, the contemners had nothing to do, my lord, after, my lord,
Yes,
they
you already
executed
submitted.
on 18th of July.
Yes.
Here, my lord, the distinguishing factor is, my lord, that the stamp duty was to be paid and that was paid, and the registration thereafter steps were taken. And the executant said, my lord, I have placed, my lord, the respondent number 7 said that I executed a further document.
After the
order.
Authorization in the order.
On the basis
Authorization
of
and
order.
paying the yes. Yes. Anything further?
The document dated 4th April did not by itself, etc. My lord, it's not. Here, my lord, 47A, may I, my lord, place this paragraph.
Yes, yes.
The document dated 4th April 2013 did not by itself create any interest, nor did the title pass upon the execution of such document on 4th April 2013. But it was only after the registration on 2nd July 2014 that the title to Cartier property passed from the company. The submission of the contemner, however, is that by virtue of section 47 of the Registration Act, the document in question would operate from 4th April. In our view, the principle embodied in section 47 of the Registration Act is completely for different purposes. Insofar as the issue of transfer is concerned, section 54 of the Transfer of Property Act is the governing principle, which is quite clear. It is the date of registration of the document which is crucial in as much as the transfer is effected and the title passes only upon registration. Viewed thus, it is clear that Cartier property was transferred in the teeth of the order of 8 May 2014. As I have, my lord, at the sake of repetition, things were done after the orders were passed. Here, my lord, the distinguishing feature is, my lord, nothing was done after
By you.
The order was passed
By your client.
by my client.
And the registration.
My lord, kindly, my lord, I may have missed something, my lord. Sorry? 8614, sir. Paragraph. Huh? Page 614. Okay. Oh, yes. It have দেখালাম না? Miss করে গেছি। I missed it, yes. My lord, kindly once come to page 614. I'm sorry, my lord, I missed it, though I had marked it, but I missed it, my lord.
Yes.
Paragraph 14. Kindly come to my lord, placitum G. Subparagraph E. That on 2nd July 2014, I and Mr. No, before that, my lord, may I please? Paragraph 14, my lord, last 3 lines before the quotation. In his subsequent affidavit dated 27 January 2016, alleged contemner number 17 submitted that he directly worked under the alleged contemners number 2 and 3, and that he used to sign documents on their instruction. He submitted as under. Then kindly omit, my lord, this first quotation, then E. That on 2nd July 2014, I and Mr. Shobhananand Jha signed certain documents before the registrar office on the instruction of Mr. So-and-so. I did not have any occasion to read this said document, nor was I aware of the contents of this said document, and the particulars of the property in respect of the sale deed was signed by me. After putting the signature, photographs were taken. Thereafter, I returned to Delhi and informed Mr. So-and-so that the paper have been signed. Now here, my lord, photographs were signed, photographs were taken on, my lord, 18th of July, as I have shown. Now, my lord, the other decision which has been relied on, reported in 2017, volume 2, Supreme Court cases, page 456.
Yes.
I have never seen such, my lord, reporting, my lord. If your lordship is pleased to come to the first page, lordship will find at the top 2017 2 Supreme Court cases, page 456. Then, my lord, kindly come to page 460. I really do not know, my lord. Page 460, kindly come to. At the top, lordship will find 2017 2 Supreme Court cases, page 460.
Correct. No, this first one
Yes.
is a record of the proceeding. If you come the first page,
yes,
see the 2017 volume 2 SCC record of the proceeding within bracket.
That's true.
Then the 460 is the order dated 8 July. Order dated 8 July.
Very well.
Then come to the 463.
462 also.
460. Acha, 462.
462.
462 order dated.
Yes.
Then 463 is the judgment. Judgment dated 15 December.
I was wondering, my lord, how it is.
So we are quoting the para wise, but here it has been quoted the date wise.
Kindly come to paragraph 32.
Yes.
At page 475. From the record and the inquiry report as stated above, it is clear that soon after the order dated 24th October 2013 passed by this court, The respondent remained admitted in the hospital for a total of 527 days. Nothing has been placed on record, nor any medical condition or reason have been adverted to why such admission was required in the first place. As found in the inquiry, no laboratory test was conducted during the period of admission from 25th February 2014 to 12th April 2014 and from 12th April 2014 to 1st May 2015. This shows that the illness as projected was not serious at all and no intensive treatment as indoor patient was required or called for. This prolonged admission without any justifiable medical reason was essentially to defeat the direction issued by the court in its order dated 24th October 2013 and repeated non-bailable warrants issued by the trial court. Then paragraph 34, again, my lord, the conduct of the doctors and the, my lord, hospital authority. Similarly, 35 also.
Yes.
My lord, what happened, my lord? The patient was, the person was, my lord, after the order was passed, my lord, he was admitted in the hospital and he was kept there. And in that context, my lord, the court has come to this, my lord.
540 days, yes.
Kindly come to paragraph 41.
Yes.
As regards the liability of the aforesaid medical professionals, questions that arise are whether a person who is not bound by a direction issued by the court could be held guilty for committing contempt of court for his conduct in either directly aiding and abetting violation of on the part of the person who is bound by such direction, and two, what is the extent of liability of such person. Then, my lord, kindly come to paragraph 46. In our view, the medical professionals, namely so and so, extended medical asylum to the respondent without there being any reason or medical condition justifying prolonged admission of the respondent as an indoor patient as a covert to defeat the orders passed by this court. And the trial court has stated above and thereby aided and assisted the respondent in violating the order of this court.
Yes.
By such conduct, these medical professionals have obstructed administration of justice. My lord, kindly give me, my lord, 10 days. Your lordship has, my lord, matters from
12:30.
10 minutes, my lord.
Further 10 minutes.
Any day convenient.
What remains?
Oh, there is one more judgment at least to be distinguished.
This is the best ground. Okay. Today the judgment I cited today.
Sensation suffering for the petitioner, sensation suffering for the alleged contemptor, counsel for the alleged contemptors are argued at 10. But due to paucity of time, hearing could not be completed. This is the matter.
In unity. In unity.
8th April. 8th April.
Well, the order is still 3rd April in that case. Well, the order is still 3rd April, so kindly extend it then till
the interim order, which is going to be expired on 3rd April 2025, is extended till 11th of April 2025, or until further order, whichever is served.
I am obliged for
Okay, 9th, just a 9th April. Is commercial? हाँ तो 9th April.
Sir, not
अच्छा 9th April.
9th April.
Well, Your Lordship, I am appearing for the petitioner in this matter. Your Lordship, This is for probate of last will and testament dated 3rd February 2010 of the executrix, Your Lordship. However, the time to time general and special citation.
यहाँ क्यों उठा है? क्या के लिए? Yes.
Lordship, time to time general and special citation has been issued upon the legal heirs, Your Lordship. It has been delivered. Thereafter, paper publication was made. Your Lordship, we are awaiting a no caveat certificate from the department. Your Lordship, the department has said that they will require 1 more week for issuance of the certificate, Your Lordship.
Department required the leave from the court for giving the leave. No caveat certificate from the court.
No, Your Lordship, they are saying that they require 1 more week, Your Lordship. They are in the process of granting no caveat certificate.
So 1 week they required.
Yes, Your Lordship. Lordship, I am just praying the matter be kept next week, Your Lordship.
So appearing for the petitioner. As per the prayer made by the counsel for the petition, the case is adjourned. Let the matter appear on 3rd April.
Grateful, Your Lordship.
Next.
Executor.
Yes.
DA1 is my application, my lord, praying for condonation of delay in filing my caveat and affidavit in support of the caveat, my lord. I have filed it in court, my lord. There is a delay, but I did not seek the condonation from the court earlier, my lord.
My lord, kindly see the last order, my lord.
Yes, my lord. Last order, my lord. It's annexed at page number 30 of my application, my lord.
30?
30.
My lord, kindly see the last order. Accordingly, the caveat is not taken on record, my lord.
Yes.
After this, I have preferred this application. I'm seeing condonation of the delay. My
Well,
lord.
kindly.
The copy?
Yes, copy is
Well,
it's also filed.
Kindly see the application, my lord.
You want to file affidavit?
Yes, I want to file affidavit.
So why you want to go telling that kindly see the affidavit?
Yes, I want to file affidavit.
So suffering for the petitioner. So suffering for the caveator or caveatrix?
Caveator, my lord.
Caveator. So caveator has filed an application being GA1 of 2025, praying for condoning the delay. Praying for condonation of the delay for filing caveat and affidavit in support of caveat. Counsel for the petitioner prays for time to file affidavit in opposition. Let affidavit in opposition filed within 2 weeks.
4 weeks, my lord.
Within 4 weeks. Reply, if any, there to be filed within 2 weeks thereafter. Release the matter on 1st of May 2025. Next.
I am for the executor. I filed an application for probate.
And for the
made an application
time to file affidavit in opposition.
Opposition, my lord.
Filed.
I have also filed.
Reply filed.
But reply not served.
Reply not served.
Yes.
Affidavit in reply not served.
Not served. And condonation of delay has been filed, my lord, without annexing the caveat. And delay, my lord, as per advertisement, 123 days.
Affidavit in reply is already served on 25th March, my lord.
Have you filed the affidavit in reply?
Yes, my lord. I am
when you
filed
filed
with all this affidavit.
Affidavit in opposition is there. Where is the reply? Now you are filing.
But
no the copy.
Copy to the.
No copy.
Yes, ready?
Yes, my lord. Affidavit of service. My lord, I am ready with both the caveat and affidavit in support of caveat. May I
first you place your application? Yes.
Yes. My lord, actually I am on delay of 50 days.
No.
Huh? The notice was served upon me on 14th November 2024, my lord.
14th November?
14th November 2024.
Where you mention?
my lord, in my paragraph number 2, page number 3 of this application, paragraph number 2.
Paragraph 2.
My lord.
Subsequent filing of the application for
Annexure
probate.
A, my lord.
The learned Sharif of Calcutta High Court by notice dated 18th October.
914, notice number 914.
Huh?
My lord, it was served upon me on 14 November. And subsequently, it is expiring on
14 November.
Yes, my lord.
It was served upon you 14 November. Yes, then
4 weeks later, it is expiring on 11th December.
4 weeks.
4 weeks.
Why 4 weeks?
No, notice, it was mentioned in the notice.
Where is the notice?
My lord, Annexure A.
Where it is mentioned 4 weeks, sir? Annexure A.
Page number 12. Annexure A, page number 3 of the notice.
Page number 12.
Top second line. Top second line.
4 weeks.
4 weeks, my lord. From the service of the deed upon them.
Opposite and place of judicature there. 4 weeks from the date of serving court house. Upon receipt of between the hours. Yes, then.
My lord, it is the date on 11th December. Due date.
Huh?
Due date is 11th December.
Due date is 11 December.
11th December.
4 weeks is 11 December.
Yes, my lord.
Yes.
And just at that period, the objector applicant number 1.
How many objectors are there? Caveats are there?
2 objectors. One
Both have filed
brother-in-law and one.
Both have filed this?
Yes, ma'am.
Partha Sen and Sakya Sen.
Yes, ma'am.
Sayak Sen, yes.
Sayak Sen. Partha Sen was suffering from serious cardiac discomfort. And had
Where
been
is the ground? What ground you have taken? Show me.
My lord, I have annexed the medical document.
Page 14, my lord. 28 January 2025, on the same day, he was discharged.
Let he submit. His case is there. If you want, he should not submit. I will hear you.
I have annexed Annexure B, man. The medical
Annexure B, page number. Date of admission 28 January.
Yes, my lord. On the same day.
But your time expired
but
on
he was
December.
suffering. Yes, my lord.
But
He
your
was
time
suffering
expired on December 28.
11 December. My lord, actually, from a very first week of the December, he was suffering.
Where you mention?
My lord, I have mentioned in paragraph number 5, my lord. On my this application.
Fell seriously in the middle of December.
Middle of the December 2024, Mr. Partha Sen fell seriously ill due to some cardiac discomfort. And today itself, he is admitted. Till today, he is now in a decent hospital, my lord. And the date.
So you are discharged on 28th of January.
Yes, my lord.
So when you file this application, 20 February.
I have affirmed it on 7th February.
7th February, but filed on?
On the same day.
20 February. Yes, then?
My lord, actually, after that, the Christmas vacation.
Christmas vacation?
Yes, my lord. Since 25th December to 1st January.
But you are in my hospital 28th January.
Yes, my lord. And I have delayed just 57 days in total since the date of due date, 11th December.
Okay. So you would have been filed the affidavit, this caveat by 11th of December, but you have filed the caveat on
7th February.
Caveat filed?
My lord, all are ready.
You have not filed the caveat. You could have
couldn't-
filed the caveat along with the application. There is no caveat. What is the condonation?
Just for leave, I have not filed it. As because the department has advised us to take.
Yes, what is the submission?
And as per my
all
lord,
the petitions are ready, my lord.
within 98 days, 70 days delay, as per my lord service, And my lord, as per
Service affected on 14 November.
14 November.
Correct.
Correct.
If he affirmed the application on 7th of February. 7th of February. Correct. He has to file the within 4 weeks.
4 weeks.
4 weeks completed on 11th of
11
December. 11th of December. So 11th of December to
He filed on, my lord, 20 February.
20 February.
That is, my lord, 70 days delay.
70.
70.
How?
And December, my lord, 19.
December
January 31st.
December 11. So there was a
20.
20 days. Correct.
Yes.
Then
January 31st.
January 31 days.
And February 20 days.
20 days. So 1 and
71. 71. No, 70.
71 days.
71 days.
My lord, I am entitled to the vacation period, the 7 days during 25th December to 31st Jan.
Huh?
Since 25th December to 31st Jan. 7 days. I am entitled to get that exemption.
Which law? Your time expired on 11th of December. Which law you will get the benefit of the winter vacation? Show me the law.
Straightway the delay is...
Your time to file the caveat expired on 11th of December. Correct. Court.
My humble
the winter
submission to
vacation.
consider this period that because that period was...
I am asking one question to you.
My lord.
Your time to file the caveat expired on 11th December.
Right.
Court was on winter vacation from 23rd of December. So 11th of December to 23rd December, how the court can condone the delay? You are telling that winter vacation is to be given consideration. First thing. Second thing, you have mentioned about the 48 days, but the delay is 71 days. Where is your prayer?
My lord, actually...
50 days.
My lord, actually...
If your court allow also the 50 days, the delay cannot be condoned.
No, my lord, actually, this is a misconception. Actually, I have calculated it for 57 days. And excluding these 7 days, it is coming to 50 days.
Which 7 days? Which 7 days you are asking for?
No, my lord. I have just humbly prayed before you. It may be considered or not. But the thing is that the information is received to me that 7th February it had been affirmed, and on the same day the application was filed before the court. But unfortunately now I came to learn that the application has been filed on 20th.
Yes, see, the official is there.
Yes, no dispute on that. So let this 70 days is to be considered, my lord.
Yes.
And 27, my lord, consequence, my lord. Original sir rules, my lord, 27. Kindly say it.
Chapter?
Chapter, my lord, 35.
Chapter 35. Rule?
Rule 27. But the caveator fails to file an affidavit in support his caveat. It can only be injunction.
Yes. Chapter 35 rule?
Rule 27.
Huh?
27.
Yes.
Consequence not filing affidavit. Where the caveator fails to file an affidavit in support of his caveat in compliance of Rule 25 or in compliance of the notice issued under Rule 26, the caveat may be discharged by an order be obtained from the source. That's some of the affidavit will be discharged.
So what is your submission?
That the said application should be dismissed.
For what?
But he did not file the application.
If the notice is received given the 4 weeks time, what would be happen? Kindly see the notice.
4 weeks.
Then
4 weeks, my lord, within the limitation period, my lord, 71 days. Therefore, he...
No, if that is different thing. You are asking about the Rule 27.
Yes.
Correct.
Within the time, my lord, 4 weeks, within the time, my lord, he never...
So that's why you're asking about the very, which is direct mandatory. The court cannot extend the time.
Yes, my lord. But in this case, my lord, without any annexing the caveat, he filed the conditional delay.
That is different. That's why I'm praying for the extension of time.
That's why, my lord, the said application is not maintained level and it is, my lord, liable to be dismissed.
So and so appearing for the petitioner, so and so appearing for the caveator. Caveators.
My lord.
Full stop. The caveators have filed the present application being GA1 of 2025, praying for condonation of the delay of 50 days in filing the caveat as well as the affidavit in support of caveat. Police counsel for the caveators submit that the notices were served upon the caveators on 14/11/2024. As per the notice, the time to file caveat has been prescribed for 4 weeks, and the 4 weeks has expired on 11th of December 2024. But the caveators could not file the caveat or affidavit in support of caveat within 4 weeks, as one of the caveator was suffering from heart ailment and could not contact the advocate, could not contact the advocates to give instruction. And subsequently, on 28th of January 2025, one of the caveator admitted in the hospital, and he discharged only on when he was discharged
in the evening on the same day,
and on the same day he was discharged. Subsequently, the caveators have contacted the learner advocate, and as per the instruction, the application was prepared and was affirmed on 7th of February 2025, and it was taken on record on 20th February 2025. Counsel for the caveators submitted that in the prayer portion, the caveators have prayed for condoning the delay of 50 days, but it should be read as 71 days. Full stop. Per contra, learned advocate for the petitioner raise objection and submit that the caveators have to file caveator and submit that the caveators have not shown any reason as to why the caveators have not filed the filed the caveat as well as affidavit in support of caveat. He further submits that till date the caveators have not filed the caveat or affidavit in support of caveat. Counsel for the caveat petitioner further submit that in terms of the original side rules, the caveators have to file their caveat as well as affidavit of caveat, but they failed to comply with the provisions of the original side rules, and as such, the application is liable to be dismissed. Any further? Heard the learned counsel for the respective parties. This court find that the petitioners and the caveators have received the notice on 14th of November 2024, and the caveator, and in the said notice, the time to file the caveat has been extended for 4 weeks. The same was expired on 14th of December 2024, but the caveators could not file 11th of December 2024, but the caveators could not file the same. It is fine from the record one of the caveator was suffering from heart ailment, and he has also disclosed the medical documents which reveals that one of the caveator was suffering from ailment. Subsequently, they filed the application. They affirmed the application on 7th of February 2025, which was taken on record on 20th February 2025. Considering the above, this court find that one opportunity should be given and one equal list. The counsel for the caveator caveators further submit that the caveat as well as affidavit in support of caveat is ready. If the court extend the time, they will file the same by tomorrow.
By day after tomorrow or 7 days, if it would be very much.
File today, I will grant.
I am ready with both the petitions.
If you file today itself, I will grant time. Otherwise, I will not grant time.
Small correction, my lord. Just
sorry.
Give me, my lord.
Just now stated that you are ready.
I am ready with the caveat and affidavit.
By tomorrow. By tomorrow. It is made clear that by tomorrow, the caveators failed to file the affidavit, caveat as well as affidavit in support of caveat. The caveat will be discharged, and the PLA will be taken, will be proceeded accordingly. GA1 of census disposed. While making the submission before the court, be very serious.
Pardon.
I am for the petitioner, my lord. Lord, they have filed an application for GA1. Lord, I am praying 1 week time for extension for opposition of the.
You are for the?
I am for the petitioner.
I am
Who has
Defiance, my lord.
what petition you have filed? Extension of time.
No.
No.
Ah.
The affidavit in support of the
Ah.
special citation.
They have filed an
GN
application to leave.
Who is for the petitioner?
I am for the petitioner. my lord.
Yes. What petition you have filed?
Lord, I have not. I have petition for grant of probate.
Ah.
They have filed a petition to leave to file caveat and.
So
in
that's why
support-
I'm asking the leave to file caveat, but
Yes,
he is
ma'am.
telling that no.
No, sorry. I am praying
What
extension.
petition you have filed?
My lord, I am engaged by the High Court Legal Service Authority. I have just got the Wakalatnama.
When you
After
got the
two
legal service
changes,
certificate, when you got the appointment of the
28-2.
28-2. Today we are on.
We are on 20.
You could not get the time to go to the department and see. Legal aid, you have put the name in the list, got the name, that's all.
No, my lord, I have got
This is the way you are conducting the case of the legal aid.
My lord, I have got the Wakalatnama on 15-3. 15-3, no objection Wakalatnama. 15-3. 15 March. 15 March, I have got the Wakalatnama.
So what do you want now?
I want to file the, there was a order to file the.
So you want to
Yes, my lord, I am praying for extension of time
Before
to
coming that record, go to the record. Census appearing for the petitioner, census appearing for the caveator, counsel for the petitioner prays for extension of time to file affidavit in opposition in connection with GA1.
Yes, my lord.
Of 2024. Let affidavit in opposition file within 2 weeks. Reply if any thereto be filed within a week thereafter. List the matter on 24th April.
My
lord.
Next.
My lord, I am appearing for the executor. Your lordship, in the testament, the testator, Vimal Kumar Katotia, mentioned 2 addresses in his will. One of the addresses, the address in the probate petition and the address in the death certificate
Are different.
Those are
What do you want?
I want to
Amendment.
the amendment, and it should be incorporated in terms of the death certificate.
That's all. Census appearing for the petitioner. The petitioner has filed the present application for amendment in the probate application. Counsel for the petitioner submitted the address of the testator in the will and in the death certificate are different. Accordingly, the petitioner intend to incorporate the
There
address.
are 2 addresses.
Intend to include the address which is mentioned in the death certificate. Consider the submission made by the counsel for the petitioner. This court find that the amendment as sought for by the petitioner is formal in nature and will not change the nature and character. Accordingly, prayer A to C of the master summons is allowed. GA1 is disposed.
Deeply obliged.
Next.
But I am for the petition, my lord. This is my application, my lord, for amendment of the cost title, my lord. Amendment of the cost title, my lord.
Amendment of the cost title.
My lord, by an order dated September 4, 2024, my lord, the probate was initially granted. My lord, at the time of drawing up, my lord.
Probate granted?
Probate granted, my lord.
This court?
By this court, my lord.
Ah.
My lord, the...
Where is the order?
In my lord, the page 7A.
Page?
7A. 7A.
78.
No, my lord, 7A.
7A.
Its number is, my lord. But the post office, my lord, there has been a typographical error in the post office.
Post office?
Name of the post office. Instead of, my lord, Lala Rajput Rai Saroni, it has been, my lord, Lajpat Rai Saroni. That is the, my lord, amendment. My lord, page 4, my lord.
What the department has done when initially the scrutiny was done? Don't know.
No.
So appearing for the petitioner. The petitioner has filed the present application for amendment in the cost paper of PLA number 100. 100 of 2024. Police counsel for the petition submitted by an order dated 4 September 2024. This court has granted probate, and when the department has processed for issuance of probate, department has pointed out that in the probate application as well as other cost papers, the name of the post office is wrongly recorded. Name of the post office of the address of the testator is wrongly recorded as Lala Rajput Rai Sarani instead of Lala Lajpat Rai Sarani. Accordingly, the petitioner intend to correct the same by way of amendment. Consider the submission made by the counsel for the petitioner. This court find that the amendment as sought for by the petitioner is formal in nature and will not change the nature and character. Accordingly, prayer A2, A, B, C, A to C of the master summon is allowed. GA1 is disputed. Right.
My lord, this is my application. My lord, today I am seeking the amendment of an affidavit of asset after grant of letters of administration. The order, my lord, page number 51, my lord has passed an order to grant of letters of administration.
Page 51.
51. 4th of September 2024, the letters of administration has been granted. Thereafter, my lord, the legal heir of the deceased opined from the bank that there are some other goods which is lying in the bank, which is not incorporated in the
Lying in the bank or bank locker?
bank, my lord.
Bank. Where you mention?
It's number 61, my lord. My proposed amendment. Some term deposits.
In the account?
Yes, my lord. Term deposits. Some different accounts. Which is not incorporated in my earlier affidavit of asset.
So in the amendment, is it more than the amount which in the main application?
He has no idea about it.
When the order was passed, page
My lord,
50.
of September 2024, 51, page number.
Probate granted.
Yes, my lord. Letters of administration.
Letters of administration granted. Then you came to know. Now you wanted to include this in the affidavit of assets. Census when suffering for the petitioner. The petitioner has filed the present application being GA1 of 2025, praying for amendment in the affidavit of assets in connection with PLA number 105 of 2024. Police counsel for the petition submitted by an order dated 4 September 2024. This court has granted letters of administration, and accordingly administration is issued. Accordingly, letters of administration
Very next page.
administration have been issued. But when the petitioner has processed in terms of the letters of administration granted by this court, it was found, the petitioner found that several deposits are lying, all State Bank, are lying with the State Bank of India and other banks, and as such, the petitioner intend to amend the affidavit of assets by incorporating the said details. Considering the submission made by the counsel for the petitioner, peruse the application. This court find that the amendment as sought for the petitioner will not change the nature and character of the main application for grant of letters of administration. In the application also, prayed for amendment. Then क्या बोला? Correct. Accordingly, prayer A2 D of the master summon is allowed. GA1 is disposed of. Next, 59.
Lordship, in this matter, Mr. Lalothan Mondal is appearing. Lordship, he is on his leg before courtroom number 1, Lordship. I'm praying for an adjournment on his behalf. Lordship, in this matter, Mr. Lal Ratan Mondal is appearing on behalf of the petitioner. Lordship, he is on his leg before courtroom number 1. Lordship, I'm praying for an adjournment on his
What
behalf.
is the application for?
Lordship, I'm not brief in this
Why?
matter. I'm just being informed right now.
Not today. Next.
Actually, this is my application under section 283, subsection 3 of the Indian Succession Act, in an application for grant of probate. Lordship, all the legal heirs of the testator have consented to the grant of probate. I was praying for a direction for publication of notice in the local.
Where the property?
It is in district Churu, Rajasthan, Lordship.
District Juru.
Churu.
Juru.
It is at prayer A of the master's summons.
Where is the affidavit of assert?
Lordship, it is annexed to the affidavit in support of the master's summons. It starts at page 5, Lordship.
Page 5.
And the property is mentioned at page 7, Lordship.
Which
D2.
property?
D2.
Which property?
Lordship, page 7, D2.
Page 7,
D Roman 2. Is that?
Acha, 2. Residential flat SBN 306, third floor.
In village Salasar, Tehsil Sujangarh, district Churu, Rajasthan.
So appearing for the petitioner. The petitioner has filed the present application under section 283 within bracket 3 of the Indian Succession Act. Praying for praying for a direction. Praying for leave to publish the notice of the case. Next, file the application with under section Indian Succession Act. Praying for submits that one of the property is situated outside. Is situated at village Salasar, SALASA, Salasar, Tehsil Surajgarh, Sujangarh, SUJANGR, Sujangarh, district Churu, state of Rajasthan. That is the outside of the jurisdiction of outside the state of West Bengal, and accordingly prayed for publication of the notice in the English daily newspaper and Hindi daily newspaper, which is widely published in the Churu district, Rajasthan. Consider the submission made by the counsel for the petitioner. Petitioner granted leave to publish the notice of the case with respect of the property situated at Churu district, Rajasthan, in the English daily newspaper. Which paper?
I'll have to find out, Lordship, which is the most widely circulated. One English and one Hindi. One English and one.
But name is to be, otherwise the department will not accept this. Churu, Rajasthan, which paper? Janmat.
I need to ascertain that, Lordship, frankly.
So what can be done? Hindi. You ascertain, then I will. Can you see in the Google what are the papers?
Lordship will kindly grant me 10 minutes.
Yes.
Lordship. Thank you.
So within 3 weeks from date, the department is directed to issue the proper form of publication of the notice in the aforesaid notice to the petitioner within 2 weeks from date. GA number this.
I am for the petitioner. My lord, one of the consent affidavit, my lord, died, my lord, constituting one of the consent affidavit died, my lord.
Consent?
Affidavit.
Consent affidavit is died.
Yes, my lord.
Consent affidavit is died.
So what is consent affidavit, my lord? Legal years, my lord. One of the legal years, my lord.
Where is the name of the legal heirs? In your application?
Govinda Mohan Maiti, yes, my lord.
Madam, till the disposal of the case, your will be out of record. How many legal heirs?
2 sons, my lord.
No. How many legal heirs? 1, 2, 3.
Yes, my lord.
How many legal heirs? A, B, D, E, F, G. Who died?
Died, my lord, Govindo Mohan Maiti, my lord.
Which serial number?
Probate petition, my lord. Proposed petition. Annexer B, Govindo Mohan Maiti. Govindo Mohan, page 3, my lord.
Govindo Mohan Maiti.
Yes, my lord.
Where is the death certificate?
Annexer B, my lord.
Annexer B.
Yes, my lord.
When he died? 12 January 99.
27th April 2024. Govindo Mohan Maiti.
Page 7. Death certificate is?
Annexer B, my lord.
Annexer A.
Annexer B.
Annexer B.
Yes, ma'am.
Govindo Mohan.
Page 80. Yes,
Maiti, yes. On 24.
Yes, ma'am.
So what you want here? Only recording the death.
Yes,
What is the legal heir?
Legal heir, my lord. 2 sons, my lord.
Where is that?
2 sons, my lord.
His wife is also died.
Wife is also died.
So 2 sons.
Yes, my lord.
Where you mention?
Mention, my lord.
Amit Kumar Maiti and Samit Kumar Maiti.
Yes, my lord.
These are the 2.
Para 7.
These are the 2.
Yes,
These are the 2 persons.
Yes, my
lord. So suffering for the petitioner. The petitioner has filed the present application, being GA1 of 2024, praying for regarding the death of one of the legal heirs of the testator, namely Gobinda, Gobinda, Gobindo Mohan Maiti, Maiti, who died on 27th April 2024, leaving behind his 2 sons, namely Amit Kumar Maiti and Samit Kumar Maiti. Counsel for the petition submitted. The wife of the deceased, Govinda Mohan Maiti, was predeceased to him, who died on 12th January 1999. At the Learned Counsel for the petitioner perused the death certificate of Govinda Mohan Maiti and the wife of the Govinda Mohan Maiti, full list of the name of letter
Niva Noni Maiti, deceased, my lord. Niva Rani হয়ে গেছে।
क्या बोला? Consider the submission, so prayer A to E of the GA must be master summon is allowed. GA1 is disposed.
Grateful.
This is my application, my lord. I'm for the petitioner. This is to amend and re-verify the original probate application, my lord. To amend and re-verify the original.
Why?
My lord, we'd kindly come to page 23 once.
Page 23 of the application?
Of the.
Yes.
Lord, if my lord will kindly see annexure B, page 23 at the last, my lord. So inadvertently, the fees payable to the advocate has been mentioned in the affidavit of assets, my lord. That has gone down wrongly, my lord. I'm praying that has to be deleted.
So instead of 2,50,000, 97,000.
Correct.
And
and the application, probate application has to be amended accordingly, my lord.
So this is the affidavit of assets.
This is the affidavit of assets.
This is affidavit of assets. And you want to amend the probate application?
Probate application.
Which paragraph?
My lord, I have stated.
Paragraph 5.
Paragraph 5(6), my lord.
That's all.
Yes, my lord. So I'm seeking prayer, my lord, in terms of prayer A, B, C.
So suffering for the petitioner. The petitioner has filed the present application, being GA1 of 2024, praying for amendment in the probate application.
Probate application.
Probate application as well as
affidavit
of assets. Consider the submission made by the counsel for the petitioner, peruse the proposed amendment. This court find that the amendment as sought for by the petitioner is formal in nature. Accordingly, prayer A to D
correct
of the master summon is allowed. G1 is disposed of. Next.
Much obliged.
This is my application, Lordship. The
there is the application is in regard to the paper publication as one of the assets of the deceased is lying outside the jurisdiction, Lordship. The deceased has passed away.
Which property?
Yes, Lordship.
Which
Lordship
property?
kindly comes to page 6.
Page 6 of this application.
Yes.
Hmm.
It is the affidavit of asset.
Correct.
And internal page, page 8. If Lordship kindly comes to page 8, the first immovable property which has
Darbhanga.
Yes.
That's only one property.
This is the immovable property which is outside the jurisdiction. There are two other bank
Where it is?
bank accounts. Page 7.
Page 7.
3.
IDBI.
State Bank,
State Bank, Darbhanga.
Darbhanga Medical College. Then next 4, Indian Bank.
Darbhanga.
Yes. These are the 3 assets, Lordship, which lies outside the jurisdiction.
Notice. So what do you want?
I want paper publication, Lordship, in 2 newspapers, one English and one Hindi. Local newspaper. English is Times of India and Hindi is Sanmark.
Sanmark is there.
Yes, Lordship.
Darbhanga, it is there, Sanmark.
Yes. What I have been informed by my client. There are 2 heirs, the father and the brother.
They come. They have given the consent.
Yes.
So and so bring for the petitioner. The petitioner has filed the present application under section 283 within bracket 3 of the. Counsel for the petitioner has filed the present application praying for leave for publication of the general citation in the English daily newspaper, namely Times of India, and Hindi daily newspaper Sanmark, on the ground that one of the immovable property and 2 immovable property, that is the bank account of the deceased, is situated. One of the immovable property and two bank accounts of the deceased is situated at Darbhanga, Bihar.
Yes, Lordship, Bihar.
Darbhanga, Bihar. The district, where is the
district is Darbhanga.
Darbhanga. District Darbhanga, state of Bihar. Full stop. At the learned counsel for the petitioner perused the application. The petitioner is granted leave to publish the notice of this case in the English daily newspaper Times of India and in the daily newspaper Sanmark in the district of Darbhanga for the information of the interested person with respect of the property left behind by the deceased. Within a period of 3 weeks. 3 weeks. Full stop. The department is directed to issue the proper format of the notice, which is to be published in the aforementioned newspaper within 2 weeks from date. GA number GA number 2 of 2025 is disposed.
Grateful, Lordship. Grateful.
Next.
Lord, I am appearing for the petitioners in this matter, my Lord. This is an application again under 283(3) of the Successions Act, my Lord, for issuance of citation, my Lord, through the district court.
Judge.
Yes, my Lord. My Lord, there's only one property, my Lord, which is situated beyond the jurisdiction. The property is situated in Bombay, my Lord.
Which London?
Bombay, my Lord. Not London, my Lord. Unfortunately, I do not represent such rich clients, my Lord. So that is situated in Bombay. My Lord, will find it at the prayer page, my Lord. It has been
if it is
indicated.
London, then could have been seen.
Then I would have requested your Lordship to appoint me as a receiver or a commissioner, my Lord, so that I would have got a chance to visit the property
Why
myself.
not the court should go there and inspect?
My Lord, we could together have gone, my Lord.
Yes.
There's only one property, my Lord, one immovable
Where is the affidavit? Affidavit of asset. Which property?
The affidavit of assets, my Lord.
You not come with the affidavit of asset.
My Lord, I haven't, my Lord, but I have indicated in the application, my Lord. My Lord will find at the prayer page, my Lord. There's only one property which is situated in Bombay.
Where you mention?
My Lord, in paragraph, I think, my Lord, paragraph 5 of the application, my lord. Either paragraph 5 or
No, London district judge, property situated jurisdiction. Paragraph 2.
yes, my lord.
So applying for the petitioner. The petitioner has filed the present application under section 283 within bracket 3 of the Indian Succession Act for issuance of citation. Counsel for the petition submits that one of the property being apartment number 701 situated at Radha Krishna building, Siddharth Nagar, Borivali, East Mumbai. 3. 400,066 at measuring about 1100 square feet super built up area. Full stop. Consider the submission made by the counsel for the petitioner. Prayer. A to C of the master summon is allowed. J1 is disposed of.
I'm extremely grateful, my lord.
Next.
Lordship, I beg to appear for the petitioner. Lordship, this is my GA application in connection with the grant of letter of administration for carrying out certain amendment. One is in the cost title of the main application and the prior of the main application.
What is the
May I illustrate? At the time of scrutinization, which was carried out by the testamentary department, it dawned upon them that the address which was issued by the KMC in the death certificate, it is not congruent what we have mentioned in the main application. May I indicate? It is at page number 9 of G application.
You also want to include the address which is mentioning in the death certificate?
Lordship.
And along with the address mentioned in the will?
Lordship.
And
the prior which I have mentioned in page number 17 of the G application
what prior?
For the furnishing of the bond.
This was not
bond.
included there.
It was not included, Lordship.
So applying for the petitioner. The petitioner has filed the present application for amendment in the application being PLA number 188 of 2014 for grant of letters of administration in the cost title as well as in the prayer portion. Counsel for the petitioner submit that in the cost title, the petitioner counsel for the petitioner submit that in the death certificate and in the will of the testator. It's a will. Will is there? No.
Lordship, the
will is not there.
Will is not.
Counsel for the petitioner submit that in the death certificate, the address of the testator, address of the not testator kahin nahi aayega. Address of the deceased is different than the address mentioned in the application, as well as the petitioner has not incorporated the prayer for grant of letters of administration. Accordingly, the petitioner intend to add the prayer in the prayer portion of the application for grant of letters of administration.
May I indicate? Prayer should be which we want to incorporate for furnishing of the bond.
But you're given the total right.
Lordship is following page number 17 of G application.
Yes.
It should be yes, Lordship, and I'm mistaken.
You want the total prayer.
Total. I'm mistaken.
Correct.
Correct. I was under the impression that only for furnishing of the bond. It is.
Okay. Prayer portion. Consider the submission made by the counsel for the petitioner. Peruse the amendment as sought for by the petitioner. This court find that the amendment is formal in nature and will not change the nature and character of the application. Accordingly, prayer A to C of the master summon is allowed. J1 is disposed of.
Much obliged.
Appear for the executor.
This is my learned friend's PLA application, my lord. Here I filed an application being IAGA 1, my lord, for dismissal of the application, PLA application, my lord, for want of jurisdiction. Lordship will find, my lord, the admitted cases that, my lord, the testator last place of abode was outside the jurisdiction in Bombay, and my lord, one immovable property disclosed in the affidavit of assets also in Bombay.
No property in Calcutta.
One bank account, my lord, is
bank
shown.
accounts is
Apart
there,
from
my
that,
lord.
there is nothing.
My lord, before
So ex facie, my lord, it is not maintainable.
my lord, the locus of the applicant, my lord, herein, my lord, is questionable, my lord, as of now, my lord, because no citation has been issued, my lord, no
I need
caveat
not
has
wait
been filed,
for
my lord.
citation
You
to be
want to
issued. I
file
am the
affidavit?
But I
husband of
would
the
like to
deceased.
file an
Let
affidavit,
him
my lord. There are certain points
let
I'd
him
like to
file
bring on
affidavit.
record, my lord, as well.
My lord, I am praying for a stay at the outside because ex facie it is not maintainable. I am the
Affidavit.
husband of the
Stay what
deceased.
will come because the
My lord,
application
there's
will
no
not be
stay, my
taken.
lord. There's no option of stay.
So and suffering for the petitioner, so and suffering for you are appearing for whom?
I am the
Caveat.
husband of the deceased.
My lord, he's just an applicant.
So and suffering for the applicant. The applicant has filed an application being GA1 of 2024, praying for dismissal of the application filed by the petitioner for grant of probate.
Yes, my lord.
Grant of probate. Counsel for the petitioner prays for time to file affidavit in opposition. Let affidavit in opposition be filed within 2 weeks. Reply, if any, there to be filed within a week thereafter. Release the matter on 25th April.
Grateful, my lord.
Next. Yes. Not today.
As far as item number 60 is concerned, Lordship, the vernacular paper is Dainik Bhaskar, which is a Hindi paper, and there is no widely circulated English newspaper as I understand, but I have given the name of the Times of India, which is reasonably circulated in the district.
given that?
I have given the names, Lordship.
Yes, next.
The honors did may I just mention, my lord?
Yes.
My lord,
Mentioning now this. Present.
Yes.
Repeat after me, sir.
Yeah.
I
I
solemnly affirm
solemnly affirm
that
that
in whatever
in whatever
I will depose
I will depose
by way of evidence
by way of
in
evidence
this suit,
in this suit,
I
I shall
speak the truth,
speak the truth,
no part of it
no part of it
shall be false,
shall be false,
and I shall not
and I shall not
conceal anything.
conceal anything.
What is your name, sir?
Soumitra Sen,
S-O
Umitra
S.
Sen,
Father's name?
late Shochindra Chandra Sen,
S-A
CH
C-H
INDRA Chandra
Sen.
Sen,
Age, your age,
67,
your occupation,
business,
your residential address, sir.
flat number 3A, Urboshi,
U-R B-A-S-I
BASHI,
S-H-I.
12C Kamak Street, Kolkata 700017.
My lord, I filed the judge's brief of documents in 5 volumes, my lord. May I commence?
5 volume.
5 volumes, yes.
What is the case? Recovery.
Recovery.
Okay, continue.
My lord, I have
some repetition of documents might be there. That's why it's become so.
Yes.
My lord, I have taken out a formal application for extension, my lord.
For what?
For to file written statement. My lord, my written statement has
Suit has been made ex parte long back, my lord. Kindly see the order of 12th February 2025.
My lord kindly keeps it.
Huh?
The next week, my lord. My lord, my written statement has been affirmed. I could not file it due to.
So we've not been served with any application.
There is no application on record, sir, as of now.
And my lord will kindly note, my lord, this is a suit which was originally filed in the commercial division. Order 7, Rule 10 situation, plaint returned, filed before the ordinary original civil jurisdiction. My lord, so it is a continuation of the same suit. It was ex parte then, and it continues to be ex parte.
My lord, I beseech your lordship to kindly take it up. My application
Let the witness have your application when will come, you will see to that.
My lord.
Mr. Sen, are you arrayed as a party in this suit?
Yes, I am.
Can you tell the Honorable Court who you are in this suit?
I am one of the landlords of the property.
Can you tell the court whether you are a plaintiff or defendant in this suit?
I'm the plaintiff in the suit.
Who are the other plaintiffs in the suit?
Shamosri Sen, Shiladitya Sen, Rajashri Sen.
What is your relation to each of these persons?
My Shamosri Sen is my sister-in-law. Shiladitya Sen is my nephew. Rajashri Sen is my niece.
Can you tell the Honorable Court the address of the premises in question in this suit?
12B Kamak Street, Kolkata 700017.
Who are the owners of this premises?
Soumitra Sen, that's me. Shamosri Sen, Shiladitya Sen, and Rajashri Sen.
Shown document at PD1 of the judge's brief at page 1. What is this document?
This is the deed of lease.
Who has executed this deed in favor of whom?
This deed was executed by my father, late Shochindra Chandra Sen, my uncle, late Shamarendra Chandra Sen, and the other party was Indian Oil Corporation Limited.
Is this a certified copy of this lease?
This is the original copy has been given to the court, and this is a certified copy.
Yes, my lord, original is present, my lord, if your lordship would like to see it. Original, if I'm actually like to identify the signature. The original. Can you identify that this is the original of the document?
Yes, this is the original of the document.
Original, sir. Next. How do you recognize the signatures of your father and uncle appearing on this document?
The signatures are recognized by virtue of me having seen their signatures. Their signatures in the past when they were alive.
A document is tendered in evidence. PD1. Certified copy.
Certified copy?
Yes, my lord. Original is with the defendant. Original is with the defendant, so my lord, certified copy.
Exhibit A.
Shown document at PD. Sorry.
Yeah, that's suit. दूसरा suit का है. हम 1 minute. Sir. Yes. Sir. Yes.
Shown document at PD2 of the judge's brief at page 29. What is this document?
This is the death certificate of Shamarendra Chandra Sen, my late uncle.
A document is tendered in evidence.
Exhibit B. Next.
Shown document at PD3 at page 30 of the judge's brief. What is this document?
This is the death certificate of my late father, Shochindra Chandra Sen.
Exhibit
Document
C.
standard.
Exhibit C.
Shown document PD4 at page 31 of the judge's brief of documents. What is this document?
This document is the death certificate of my late uncle's son, Shantanu Sen.
Document is standard.
Exhibit D.
Shown PD5 at page 32 of the judge's brief of documents. What is this document?
This is the death certificate of late Shamarindra Chandra Sen's wife, my aunt, Joyshri Sen.
Document is standard.
E.
Shown PD6 at page 33 of the judge's brief of documents. What is this document?
This is the probate of will done by Shochindra Chandra Sen, my late father.
As per this will, to whom did the suit premises devolve?
As per this will, the suit premises devote to my 50% was devote to me, that is being his share of the property.
Yes. Has probate been obtained in respect of this will?
Yes, it has.
Shown, my lord, document is standard in evidence. Document is standard, my lord.
Original है?
No.
Certified copy है?
My lord, the next document is a copy of PD6.
Now this is.
I'm showing. I beg your pardon. PD.
PD6.
Yes.
ये है ना? इसको
So may I show it to him?
original will go.
My copy is there, my lord.
That is a copy.
Yes, my lord. The judge's brief naturally. Please identify this document.
Yes, this is the original of the probate of will of late probate of will of late Shochindra Chandra Sen.
Document is standard, my lord.
Exhibit F. Exhibit F.
Next. Shown PD7 at page 46 of the judge's brief of documents. What is this document?
This document is case filed with the City Civil Court at Calcutta relating to unauthorized construction on the premises by Indian Oil Corporation.
Who has affirmed this plaint?
I have affirmed this plaint.
Document is standard, my lord. PD13.
Copy?
Yes. Yes, my lord. Copy.
Certified है? Signature है इनका?
What do you have to say about the contents of this document?
The contents of this document is that it has been held under injunction, and the city civil court have not given permission for this construction sought out by Indian Oil Corporation.
It is a copy. There's no signature. You not obtain the certified copy. Then,
my lord, I'm not tendering this now. I'll go move to the next document. Next. Serial number. Okay, so PD 15. Okay. Coming to that. Right. Shown document at PD 15, page 370 of the judge's brief of documents.
370.
Shown, what is this document?
This is the document which was relating to the commercial suit filed in the High Court. And the document is between the plaintiffs and the plaintiff and the defendant.
Please identify this document.
Yes, this document is the original.
Will I be correct?
Certified, huh? Certified copy. Certified. Certified copy.
Certified copy. Document is standard, my lord.
Exhibit
G. Next. Shown PD 16 at page 388 of the judge's brief of documents. Directly. What is this document?
This document is the plain file in the High Court Commercial Division relating to the case between ourselves and Indian Oil Corporation.
Who has affirmed this affidavit?
I have affirmed it.
And the document is standard. What do you have to say about the contents of this document?
That the contents is of the document is basically declaring Indian Oil Corporation Limited as trespassers, and they have been given eviction notice, but the court did not allow the commercial division that it to be a commercial matter, and thus it had to be shifted as a ordinary matter.
Are the contents of this document true and correct?
Yes, it is.
The document is tendered.
Exhibit H, and it is certified.
রেকর্ড যে আছে রেকর্ডে যা বলেছে সেটা তো থাকবেই, এটা তো cannot be improved or worsened. Shown document at PD 17, page 402 of the judge's brief of documents. Who has affirmed this affidavit? No, of course not.
I have affirmed this affidavit.
Shown page 405 of the judge's brief of documents. Is the answer to the previous question correct?
No, the previous answer is not correct.
Please tell the Honorable Court who has affirmed this affidavit.
This affidavit was affirmed by Shubrat Narayan Bhola, son of Shamashundar Bhola, aged about 43 years, working by occupation service, working for GAIN at Kolkata Divisional Office, fifth floor, IBP House, 34A, Nirmal Chandra Street, Kolkata.
On whose behalf has Mr. Shubroto Narayan Bhola affirmed this affidavit?
On behalf of Indian Oil Corporation Limited.
Document is tendered.
Exhibit H. I.
18 90 টা করতে পারি এবার আছে তো ও সেটাই জিজ্ঞেস করছি shown PD 18 at page 452 of the judge's brief of documents. What is this document?
On the service.
This document is the judgment of the court.
तो कहाँ है करेक्शन होके आई नहीं है कल 7 बजे भेजा आज हम सुबह ही 10 बजे वापस भेजे कहाँ है कौन लेते हैं सब डिक्टेशन
But I'm tendering this document.
Yes.
Shown. Document at PD 19, page 466 of the judge's brief. What is this document?
This document is a letter issued by my appointed advocate to Indian Oil Corporation Limited.
Shown. PD 469. Sorry, page 469 of the. Oh, so I handed up the wrong document. Everything kindly. 19. Yes. Shown page 469 of the judge's brief of documents. What is this document?
This document is the speed post receipt of the letter which was issued by the advocate to Indian Oil Corporation.
What do you have to say about the content? Are the contents of this document true and correct?
Yes, it is true and correct.
The document is standard. Same
Exhibit.
It's one document. Collectively, my lord, one document.
Is it along with the AD card?
It's one, my lord, marked as one exhibit. Tracking report is there, my lord.
Tracking report,
Yes,
that's
is identical.
collectively.
Shown PD 20 at page 471 of the judge's brief of documents. What is this document?
This is an email sent by an officer of Indian Oil Corporation by the name of Ajit Anurag.
Who is the addressee of this email?
The addressee of the email is the Divisional Retail Sales Head, Kolkata Divisional Office. And the email, the covering email, has been sent by Ajit Kumar Anurag.
Is your name appearing on this document?
Yes, my name is, it is addressed to me.
As an attachment.
Will it be correct to say that the document at page 472 of the judge's brief is an attachment to the email appearing at page 471?
Yes, it is correct to say so. And it has been clearly given also in the covering email.
Shown document at page 473 of the judge's brief of documents. Who has issued this? Who has issued this certificate?
74.
I have issued this certificate.
Are the contents of this certificate true and correct?
Yes, it is true and correct.
My lord, the document PD 20 is collectively, my lord, tendered.
Xerox copies.
Beg your pardon, my lord?
One is the mail, another one is?
It is an email, my lord. There is an attachment to the mail and then his certificate, my lord.
Certificate of 65. No. You have filed another affidavit? No.
No, my lord, sir.
Then this is not the affidavit. Where is the affirmation?
Original.
It is not an affirmation. It cannot
Then
be
I
yes.
don't. I kindly reserve this. I do not tender this today, then, my lord. Kindly leave this. So, this certificate copy to Eight, sir, eight certificate copy, sir. No, eight certificate copy. Yes, sir, eight is. That's it. Shown PD 21 at page 475 of the judge's brief of documents. What is this document?
This particular document is certified lease of another property in the same area as our property, which establishes the market rent prevailing during the time the eviction notice was given, and to establish the present market rent of our property.
How did this document come to your possession?
This document came to our possession through officially applying for the lease deed from the authorities by our appointed advocate.
Another document is tendered.
Certified copy?
Yes,
Yes. Exhibit L.
No difficulty, sir. Yep.
Next.
My lord, two documents are remaining. May I come back on another day for those?
So and so suffering for the plaintiff. So and so suffering for the defendant. Plaintiff witness is present. During his evidence, documents were marked as Exhibit A2. Exhibit L. Counsel for the plaintiff pressed for time. Accordingly, chief of the plaintiff witness number 1 is Defo. Case is adjourned. Let the matter appear. Give the date. 23rd June at 3 p.m.
But I have already taken out an application. It is with the learned master. It is with the learned.
It is listed will take the matter, no problem. That's why I told, because it is listed. If it's your matter will come, if your application is listed, saw the copy, I will take the matter.
Yes, we will serve. We will definitely serve. After we get a number, we will definitely serve.
My lord, one clarification with regard to my lord PD 20 in my lord's judge's copy of the judge's brief, my lord. This is a signed certificate.
Huh?
PD 20, my lord, at page 471. This is a signed certificate, my lord. If it is appearing in my lord's brief. If your lordship will.
ये रखा ऊपर रखा हुआ है.
Page 466 471, my lord. की बोल रहा हूँ
471.
हाँ इसी के नीचे. हाँ my lord at 474.
474 signature is there.
Yes, ma'am.
Where is the affirmation? Affidavit means what? Affidavit either before the notary public or to the oath committee.
Very well, my lord. I appreciate. We'll have to do that.
Because 65B.
We'll take care of it. I'm grateful.
Further evidence.
Grateful, my lord.
Yes.
This my plaint. The suit is for defamation. The issue is here, the plaintiff had purchased few shares of the defendant in a company.
Plaintiff purchased
few shares of the defendant. Where he was the promoter, the defendant was the promoter, and the shareholder. Now, the plaintiff had purchased few the entire company by by purchasing the entire shareholding of the defendant. Now, the defendant was accordingly was removed on 12th of July 2024. You will find it at page 64 of the application. 64. I will kindly find the resolution under section 169. Now, 65 is the explanatory statement.
Pursuant to provision 169.
Yes.
Mr. So is hereby removed. From the office director
Yes.
company.
Yes. Now, my lord,
Raft motor.
Raft motors. My lord will find if my lord is traveling from that part, Salt Lake, takes the Ma flyover and AJC Bose Road. There is a hoarding over AJC Bose Road that Saurav Ganguly is riding a bike. That's the new bike which is being used by now Zomato and Swiggy the EVs. Now this company was taken over by the plaintiff. Now kindly takes page 66. This is the the SH4 form. SH4 form.
Page 65.
66.
Yes.
Now this happened with all amicably. Suddenly we receive an email from one of the person unknown person kindly comes to page 71.
What is the page 66?
66 SH4
SH4
form
transfer.
that has to be filed.
Transfer.
Now kindly see page 71. This is where it triggered all.
71.
Number 71. Where this is and we find he is writing back to us that he has purchased 25,000 equity shares from the defendant after defendant had sold away the shares. Kindly see kindly see here.
This has been sent by the Raft Motors.
Raft Motors.
That is the defendant number 1.
Yes.
Correct.
Yes.
And to whom?
Then for the defendant number 1.
Huh?
Raft Motor to Ashok Kumar Chokhani.
Correct.
Yes.
Well, may I?
Yes.
I would have allowed him to continue, but my lord, may I just start from a different angle, my lord? This is a defamation suit, defamation and malicious false suit. So, my lord, I'll be asking for an injunction. Now, what is the statement they have made? Vis-a-vis that, what my learned friend was just showing will show that these are false on the face of it.
What is the injunction you have prayed for?
Sorry, my lord.
What injunction you have prayed for?
My lord, injunction not to further circulate and publish. Because, my lord, the test is simple now. So, if I can show that these are defamatory and malicious falsehood was the intent of the defendant, then, my lord, obviously, I would be entitled to an injunction. My lord, may I just show your lordship? Page 109. That will be in volume 2, my lord, first page, my lord. My lord, kindly takes page 109.
Yes.
This is annexure S, my lord. My lord, these are the, my lord, what the person is doing, my lord. May I just explain this? My lord, the defendant number 1 was the original majority shareholder of one Raft Motors. Raft Motors is not the defendant here, my lord.
Correct.
Because Raft Motors have been taken by me
Correct.
Taken over by me. Now what has happened, my lord, after I've taken over, my lord, draft motor has been doing better. So what this person has been trying to do, he has forged share certificates and tried to sell it at a premium. Now, my lord knows better than me, my lord. Once you register or you transfer a share, it needs to be registered and you need to send it to the board of directors. When it was sent to the board said these are not the shares. It did not even have folio numbers. So we informed accordingly. Now the person was caught. Now what he does, my lord, he now goes to his the LinkedIn post, LinkedIn platform, which is defendant number 2. By that platform, my lord, these are the statements he is making. Kindly now sees, my lord, page 109.
Yes.
It is with great pain and a heavy heart that I share this with you.
To whom it was?
This is written to India Today. Open Post India Today. Malad, what he is doing, Malad, kindly sees. One is India Today, Malad, kindly takes 110.
Where you from get India
Malad,
Today?
Malad, these are, Malad, posted on his LinkedIn page.
Correct.
And where he is forwarding it by saying, Dear India Today team, next page, Malad, kindly comes. Malad, this is known as tagging, Malad. These are all tags. Then 111 Dear Times Now team. Then 112 GIBS IRE Talks team.
Okay. So yes, he's
Then
sending.
Injunction services. But he's sending everywhere.
So he's sending this.
Yes.
Forwarding, not sending.
Malad, it is by tagging they forward, Malad. That is the one of the language of computers, Malad. So that is what he's doing. Now it's an open page. Everyone is seeing this. And what has happened, Malad, I'll take your lordship to that, Malad. Malad, he has also informed the BSc. BSc where, Malad, this company was going to go for IPOs, Malad. Because of this, Malad, my draft prospectus has been put at a stay. That there is some complaint. First settle that. So as it is, I'm suffering because of these, and other than that, is also having a financial effect on my company, which is Draft Motors at the moment. Now, my lord just sees the text, my lord, if your lordship kindly sees. It is with great.
Yes.
It is with great pain and a heavy heart that I share this with you. Not every individual becomes rich through hard work and dedication. Some, like, now this is the plaintiff, choose unethical paths to climb the ladder of success. As the founder of Raft Motors, a company I built with my dreams and relentless hard work, I have been a victim of fraud and forgery. My shares were illegally transferred without my consent through forged signatures on the SH4 form, stripping me of my rightful ownership in the company. Malad, may I pause there for a moment? Malad, no proceedings before any forum challenging this. As a matter of fact, he had initiated a police complaint, Malad. The police has given a report that no, nothing of that sort has happened. I've annexed that also, Malad. I've also annexed that. Now, Malad, kindly sees, while I have raised this matter with BSc and SEBI and the DRHP of Draft Motors in hold, the public deserves to know how such unethical practices are used by some to gain wealth and power by exploiting others. Malad, this is one set. Then, Malad, kindly comes to page 212.
Yes.
Now, Malad, more explicit.
Yes.
Malad, this is how, Malad, on the top, your lordship will find LinkedIn. Has your lordship got that? Malad, might get it in the stitches, Malad. Malad, kindly sees what happened to me. What happened to me wasn't the first time. Aditya Birla and his associates are habitual fraudsters, targeting innocent founders and promoters. before they fraudulently took over my company draft and stole 26 crore worth of shares. They had already done the same fraud with Milan Ghosh, the managing director of Cosmic CRF Limited. A pattern of corporate fraud and betrayal. Milan Ghosh was removed from Cosmic's directorship before the IPO, just like I was. His rupees 10 crore worth of shares were illegally transferred to such and such and his network. He raised concerns with authorities, filed an FIR against the criminals. Still fighting for justice. History repeats itself. After successfully executing the fraud with Milan Ghosh, they repeated the same crime with me. They forged my signature on SH form and share transfer deeds. They illegally transferred my entire shareholding worth rupees 26 crores to such and such, an unknown Kolkata-based person. They removed me from my own company, just like Milan Ghosh. Fighting back against a powerful fraud nexus.
Yes.
With God's grace and such, I sent all fraud details to BSE and SEBI. Then BSE took action and rejected.
These are the LinkedIn posts.
LinkedIn page. Excuse me, Malad. This is also on the LinkedIn, Malad.
Correct.
Now, Malad, may I just show, Malad, on the face of it, the intent is very prominent, Malad.
So whether this LinkedIn, you have been tagged with this LinkedIn?
Malad, LinkedIn, I needn't be tagged. I can go to his site and see who he is tagging.
It's open page.
It's an open page. Well, LinkedIn is an open page. If your lordship now ask me, I can open his page and show that.
Correct. So it is not to you.
Not to me. It's to the entire world.
Okay. Then?
It's not to me, Malad. So, Malad, this was done on 10th of March. And we have come before your lordship. Now, Malad, may I show certain documents? Malad, kindly see page 66. Malad, he has said about the SH form, SH4 form, Malad.
Page 66.
Malad, first, Malad, may I take your lordship to, Malad, page 64.
Yes, resolution.
Malad, by this resolution, he was removed from the office of the director.
Correct.
Malad, that is still date showing in the master data, Malad.
Yes.
No challenge to this. Then what he does, Malad, kindly comes to page 66.
Yes.
This is the SH4, Malad.
Yes.
On the basis of which, Malad, the shares were transferred to me.
Yes.
Oh, sorry, Malad, this one is a separate one. This is the, Malad, form SH4, which, Malad, he was trying to send or sell to one Raja Shah. Malad, kindly see transfer as particulars.
66.
66. Transfer as particulars, as your lordship got that, Malad. Next page kindly comes, Malad.
Balram Shah.
No, not the right one, Raja Shah.
Raja Shah.
So Raja Shah was being sold these many shares.
Transfer particulars.
Transfer is particulars. And he was selling. Parvesh Kumar. But now kindly sees.
No.
Rasha
Equity shares 10. 2,40,000. Transfer particulars is the Parvesh Shukla.
Parvesh Shukla is the
transfer is the Raja Shah.
Raja Shah, Malad. Then, Malad, kindly sees page 71. Okay.
Yes, then?
And then, Malad, again, Malad, then we receive a letter on 26 November 2024 from another person. His name is Ashok Kumar Chokhani. Kindly sees, Malad.
So, where from, with regard to the page 66,
Malad,
where from you got this?
Malad, this has come to me, Malad, because for transfer, I'm the board. Malad, it's sent to the company, Malad. I'm the director.
64. What is the date of the 64? 12th July 2024.
Yes, Malad.
Correct.
That is.
And 66
Yes, my lord.
is the date. What is the date?
25th September 2024.
September 2024.
After.
Okay.
Then, my lord, again, my lord, he attempts to sell to one Ashok Kumar Chokhani. That letter was sent to us also, my lord. Kindly see, my lord, page 71. Now, this is a letter where, my lord, he was trying to sell to Mr. Chokhani. Next page, my lord, kindly sees.
Yes.
There was an acceptance of Abhishek Chokhani of the 2,500 shares at 667 per share.
Page 73.
72, my lord.
72.
I confirm my acceptance to purchase in the middle, my lord. 2,500.
The trail mail.
And Abhishek Chokhani. ঠিক আছে দাঁড়ান 71 হ্যাঁ ঠিক আছে ওটা মাল্টিপ্লাই করলে তাই আসে then my lord kindly comes to 73 this is Chokhani writing to the company which is managed by me, my lord.
Yes.
My lord, he gives that he's an existing shareholder and that he was supposed to get these number of shares you are buying. Just see the last sentence. I'm providing all the relevant mails. Has he got that, my lord?
Yes.
Including a copy of share certificate received from Mr. Shukla with the request to confirm whether printing of distinctive numbers is necessary or not, and also on any other clarification. Because there were no distinctive numbers.
Yes. So Chokhani sent the letter to you.
Yes, ma'am.
Raft Motors.
Yes.
Yes.
Then my lord kindly comes to 75.
Yes.
We have received your email of sanction enclosing documents indicating offer of sale. After conducting our review and perusing the documents provided, we wish to inform you that as per records, Mr. Such and Such is not a shareholder in Raft and is not holding any shares in the company.
Yes.
He has sold all his shares and the purchaser had lodged the share certificate along with transfer deeds with the company for transfer of the shares in its name, and transfer has since been recorded.
Yes.
Consequent to such transfer, all his shareholding is not a shareholder of the company, and him claiming himself to be a shareholder and seeking to offer his shares for sale is fraudulent. The next paragraph kindly sees. The share certificate shared by Mr. Shukla is not genuine and is apparently fraudulent and manufactured.
Yes.
So, my lord, it was found that these shares were being fraudulently sold. My lord, from this, my lord, then we find when this word went around, Mr. Shukla, my lord, files a criminal complaint, which you'll find at page 77.
Shukla has filed.
Yes, my lord.
Page
77, and before that, my lord, at page 76, if you watch it, my lord, kindly sees on the right hand corner, my lord, just below this, we had made a newspaper publication informing that this has happened. But it's just, if your lordship sees in the middle of that page, my lord, to whom it may concern. My lord, somewhere here, my lord.
Yeah.
Blow up karo ichu.
Yes.
Raft Motor, my lord.
Very big notice you have published.
My lord, if
that
your
every
lordship
person
the
can-
newspaper size, my lord, I think it
Every
blow
person
up a
can
bit.
noted this.
My lord, the person who was to note has noted, my lord. Because, my lord, your lordship will find the repercussion comes the next page, my lord.
Yes.
The repercussion is 3rd January 2025.
Yes.
So a complaint is lodged regarding the fraud, he says, of his shares by using false signature. But I'm not reading the contents. But thereafter, your lordship will find what is this? Now, my lord,
So he
he makes a complaint. On 4th, I make a complaint. That is at page 83A.
Yes.
My lord,
And there
by that time, my lord, we find that he has already started making, my lord, giving those, my lord, first tranche of, my lord, statements on LinkedIn. Therefore, my lord, we issue a notice of desist, cease and desist at page 84, my lord. My lord, let us then show your lordship the police report. Kindly takes page 91A, my lord. This was being investigated by the Maharashtra police, my lord. So we wrote to them. Maharashtra, where we wrote to them that if any investigation is concluded, the report, if any, then that should be filed. Well, we got, my lord, return from that.
No, page 83.
83, my lord.
83A. Who
Sorry,
has
my
made the complaint?
83A is Raft's complaint. The company is saying that Parvesh Shukla is duping the world at large by saying that he has got shares and he's selling them.
Who is Vikram Malu?
Vikram?
Malu.
Malu, authorized signatory of the company. Well, draft notice is written there, Malat.
Okay, okay. Yes.
Then Malat kindly comes to page 'Malat, we had also supplied documents to the police, Malat. This is what was being, Malat, circulated. Kindly takes page 87.
Yes.
Malat sees this is what was being circulated, what reached us, Malat. Kindly sees no distinctive numbers, no figure, no name, nothing. Only the amount is written. So this was made a part.
So what is this? Draft
Malat,
share certificate.
These are the shares which were sought to be sold to Malat Chukhani. Malat, this was happening. That's why we filed a complaint saying that such share certificates without any distinctive number are being forged as if they are shares of the company and being sought to be sold to third parties at huge premiums. And thereafter, as I said, Malat, page 91A.
Hmm. 91A.
Yes, Malat.
Yes.
We write to the investigating officer who was investigating the complaint of the defendant number 1. If any report has been prepared, we find that a report had been prepared and we have been sent one, which is at page 92, Malat. It's in a vernacular language. Kindly comes to, Malat, page 100. The English.
Yes.
Malat, will find an extensive, Malat, investigations having been done.
What has happened to the investigation?
Malat, that is what I'm showing your lordship. Kindly takes to 108, Malat.
Police has given the report to you also.
Malat, we asked for it. We wrote a letter.
Yes.
Malat, this is where they said, he said that the signatures were forged. To that, Malat, your lordship kindly sees 7. Overall, on prima facie inquiry, it is not proved that the current share certificates of the application are legal and they did not derive any financial benefit from their alleged share sale transaction. Therefore, since it does not reflect that their shares were sold with their fake signatures, we are closing the inquiry into the said application, keeping a provision for advising to file a case in the relevant case, the provisions of the companies for validity of the share certificates. Nothing filed. Well, they are talking about a 241, 242.
This is the
report.
This is the report against the complaint of Parvesh.
Parvesh.
Not
Where
against,
he had alleged against me.
Not against your complaint.
Sorry, Malad.
Not against your complaint.
Not against my complaint. It's Parvesh's complaint.
Yes, Parvesh, yes.
It talks about Parvesh, Malad. Thereafter, as I said, Malad, he started Malad making these posts.
Yes.
Malad, this goes on, Malad. The second volume is only the posts, Malad. The entirety. Because these are being Malad tagged to everyone. So these Malad will not feel that these are separate Malad statements. These are separate taggings to show how many persons have been circulated.
Yes.
And last was Malad at Annex T.
Page
212, Malad.
Yes.
I had shown this, Malad.
Yes, you already shown.
Yes. Now, Malad, kindly sees what has happened. Malad, kindly sees 220. Malad, here I have made an alternative case. One of defamatory statements, another is malicious falsehood.
Falsehood?
Malicious falsehood. Sorry, Malad. It's been a long day, so Malad, mouth has become dry. It's not a falsehood. So, Malad, kindly sees, we refer to your application of 22nd December 2024 filing the draft prospectus of your company on the caption matter seeking in principle approval of the exchange to list its equity shares on the BSE. Use the name of the exchange in its draft offer document. The exchange has received multiple complaints among various communication exchange between the merchant banker company. The complaints the same leads to questions of the veracity and accuracy of the information. But in the capital structure of the company, in addition to the allegation of forgery, as per the police complaint. So, Malad sees this person makes statements only with the intention so that the IPO is not floated. And also, Malad, I am the managing director of the company. And I am targeted. Malad, I have given my particulars also, Malad. It's at the very beginning of the annexures, Malad, your Lordship will find.
Who has sent this? Hardik Bhuta.
That is the BSc, Malad.
BSc.
BSc, because I was floating my prospectus for IPO listing, Malad. IPO.
Yes.
So, Malad, this is what has been happening. And, Malad, I've made out a case of defamation also as malicious falsehood. Malad, kindly sees.
What is the prayer you prayed for?
Yes, Malad. Prayer is not to make similar and to bring down, Malad. Kindly take page 30, Malad.
Each representative bring down and remove all the defamatory posts. How the prayer A at this stage?
Malad, you see prayer B.
Okay.
Prayer A, Malad, I will have to call upon LinkedIn to come in.
Correct.
But if I get prayer B, I can write to LinkedIn that they have been injuncted. I mean, Parivesh has been injuncted.
So you have not made the link?
Yes, LinkedIn is party. Different number 2, Malad. Different number 2. Malad, they are basically abetting. But now, Malad, because of the relaxation on the publication on the internet, Malad, I cannot ask for a prayer, Malad, in their absence. But that would be basically against them. So if your Lordship wants to, Malad, A can be granted as a mandatory direction on the respondent, number 1.
Prayer B.
So prayer B, Malad.
Prayer B.
Prayer B, Malad.
Restraining further posting any articles. Yes, that's all.
But we'll also consider D, if your lordship. Yes, yes. না, তো ওকে কি করা হচ্ছে, এই অ্যাকাউন্টে তো মনে হচ্ছে না, ওকে ডিস্টেন্স করা হচ্ছে। সেটা তো ওকে দেখাতে বলো, ও তার
That's all.
Well, that is it. If your lordship wants to see some law, I can assist.
My appellate.
And I'll just refer those very quickly.
What?
One is your lordship's order in Mamata Banerjee, Governor versus Mamata Banerjee. Next, I have got two judgments for your lordship once.
I will block them. Yes, then.
A very interesting judgment. I would just only remind your lordship, your lordship remembers Bonnet versus Perryman. I know it comes into your lordship's mind because that has been shown by us on a repeated occasion. Now they are saying Bonnet versus Perryman is not going to be the test to the extent where jury is not applicable. For that, I've got one 1962 Calcutta High Court. If your lordship wants, I can provide that. This would only paragraph. I'll just give it to your lordship. So, this is
office.
Sorry, I took 10 minutes extra.
Call. जल्दी करो। नहीं है, कुछ भी नहीं है, छोड़ दो। Yes, call the appeal sir.
I'm just superscribing on your lordship's. Kindly does not take permission.
Okay.
May I have lordship's kind leave to mention one matter in the appeal side. The matter appeared before lordship minor, but unfortunately on that date, my lord, I couldn't appear. So matter was directed to go out of list. There's some urgency. Kindly let it appear in the list.
Out of the list. Not appeared out of the list.
Naturally. But
there is order.
Order is here, my lord.
None appears on behalf of the parties. No accommodation is sought for good.
Because I missed the list. That is true. I missed the list on that date.
List में कर देना.
Lord, may I leave to mention Lord, the list of the Honorable Justice Shubhra Ghosh. A monthly list appearing in the monthly list of item number 700. The last number, my lord. The grave urgency is there is second revisional application, my lord. The maintenance matter, the revisional code.
So why you are mentioning here?
500 to 700, my lord.
It is listed. It is there.
No, my lord, time for upgradation, my lord.
No, 500 to 700. Which serial number you are having?
700.
Huh?
700.
700. And you want the upgradation of one?
The urgency is, my lord, the
no, so many urgencies there.
Rejected my revision on the ground that the interim order passed in this 125 application is not the interlocutory order, but my contention is, my lord, the intermediate.
You are for the wife or husband?
I am for the wife, my lord. They only the granted, my lord, 2,000 rupees, my lord, the maintenance order, my lord.
For the wife?
Yes, my lord.
For their son? No issue?
No issues.
What the husband is doing?
Well, husband is in merchant navy.
Merchant
navy, my lord.
Merchant navy.
They suppress that fact, my lord, in the court below, my lord. That is the urgency, my lord.
So what the revisional court?
Revisional clause, my lord, the first revisional clause, my lord, enhance the order of the judicial magistrate from 2,000 to the 25,000. Thereafter, they prefer ex parte order. Thereafter, husband preferred the revisional application. Here, my lord, they directed the lower court to hard afresh, my lord. There, the revisional court again, my lord, the turned down the revisional application, saying that, my lord, the interlocutory application preferring the revisional application is non-mandatory. In view of the section 397(2), my lord. Because that is a certain principle, there is not the.
So this court has already passed the dispose of your original application.
No, my lord, they directed the revisional court to hear out the, my lord, the afresh.
Correct. So what do you want now here?
Now, my lord, I challenge that order, my lord.
Which order?
The revisional court order. They turned down my revisional application. There is a second revisional application. My lord. The grave urgency. I'm grave.
Yes. Call the list.
Well, I am the alleged contender. I have
Yes.
complex report to your lordship.
But I happy for the state.
Yes, Mr. Bari, have you gone through?
Yes. My lord, the at a page কত গো? পেজ কিছু করেন তাহলে আরটিআই করে বার করে চই দুটো দাও জয়সাকে দিতে হবে এ দুটো নয় তো ওদিকে দাও কপি
Yes, sir.
Madam come. Two documents. I do not know how many documents will be there. Presently, I have got two documents under RTI Act. Your lordships kindly have a look to these two documents. If your lordships permit me, I can file that affidavit to this. These two candidates, it appears that their total score is 23.27. Next is 23.26. Two documents your lordships kindly see.
23.06.
Yeah,
and another is 23.76.
76.
Correct.
Now your lordships kindly have a look to this order which was directed to be complied with by your lordships on dated 19th April 2016.
Yes.
Bolo, petition আছে তো?
Yes.
The bottom portions of the your lordship got it name?
Yes, yes.
Page 21.
Yes. Page 21 of
Writ petition.
this.
Although they have annexed in the report
Yes,
also.
that is the report also.
But there is no marking on the page.
Second page. Second page. Or first page.
First page.
Yes.
Dated 19/4/2016.
Correct. Yes.
Now your lordships, the bottom portion of the in response to the order of the School Education Department, reference one is council submitted three separate panels, namely EC and ECSC and ECOBC, without following the said provision of the existing recruitment rule. The said panel were also approved by the TI's memo number such and such. Said panel, the cutoff mark obtained by the last impaneled candidate under your category was 22.90, whereas the cutoff mark obtained the last candidate OBC category 23.61. As per the said provision existing recruitment rule, all impaneled candidates under OBC category should be included in the panel. Under unreserved category, similarly, some candidates under SC category should be included in the unreserved category also according to merit. Subsequently, upon the proposal of the council, selection of such and such. Now, these are the persons who got admittedly higher marks. They have not been included in the panel. I do not know how many fake candidates have been included in the panel. These are the RTI document. I have been able to collect these two documents only. That shows, your lordship kindly see, when they have got 23.27 marks, 23.26 marks, 06 marks, they have not been included in the panel. Is it a panel of the recast panel? What they are doing in the education matter?
Okay, do one thing. Take the exception, file the exception.
Yes,
So offering for the petitioner. So offering for the alleged contemners. Police. The counsel for the petitioner has relied upon two documents and submits that the said two candidates have obtained 23.06 and 23.76 marks. And this document, the said documents have been obtained by the petitioner through RTI. And thus the petitioner intend to take exception to the report filed by the alleged contemptor. In view of the submission made by the counsel for the petitioner.
Only not only two documents, well, there are.
No, I mentioned this. Then
yes, I will take all these.
In view of the submission made by the counsel for the petitioner, the petitioner given liberty to take exception to the report within a period of 4 weeks.
Very good.
Within a period of 4 weeks from date, please the matter on 1st of May 2020.
Yes. 1st of May. Well, can it be on 2nd? First, another matter has been fixed.
2nd, no, then it will come on 8th. 8th May.
Very good.
Yes, next.
Petitioner.
This court has already held that the respondent wife is living separately since January 31st, 2015 without any sufficient reason, and there is no evidence to show that she was ill-treated by the petitioner. Thus, the order passed by the London Additional Principal Judge, Family Court, in Miss Case number 29 of 2016, dated 6 September 2024, is set aside with respect of the grant of maintenance of 7,000 per month for the respondent wife. As regard the maintenance of the minor, this court has not interfered with.
Extremely clear. Extremely clear. Number 2.
Lordship, I am for the Havana Municipal Corporation.
It is being represented by her.
The matter is listed as to be mentioned for correction in the order dated 13th March 2025. This court find that this court passed an order on 13th March 2025, but in the cause title, the number of the year of the case has been recorded as WPA 16640-2023 instead of WPA 16640-2003. This court also find that the order dated 13th March 2025 is uploaded in the website of this court, but in the uploaded copy, the case number is correct, but the signed copy which is available in the record, the case, the year of the case number is not correct. Accordingly, in the order dated 13th March 2025, in the cause title, the case number shall be read as WPA 16640-2003 instead of WPA 16640-2022.
Your Lordship, may I say in the second page of the order, at the last bottom paragraph, Your Lordship, possibly this will be 30th January 2025 because in the first two paragraphs, Your Lordship has stated that it is 30th January 2025.
The counsel for the Havana Municipal Corporation has brought the attention of this court that in the said order, page number 2, last line, the orders is to be read as, and the date shall be read as 30 January 2025 instead of 31st January 2025.
Your Lordship, my name has been wrongly recorded as Ankjit. It will be Ankit, Your Lordship. The name of the counsel.
30 January 2025 instead of 31st of January 2025.
The name, Your Lordship, has been written as Ankjit. It will be Ankit, Your Lordship.
The counsel for the Havana Municipal Council submitted that his name has been wrongly recorded in the cause title. The name in the cause title of the order dated 13th March 2025 is wrongly recorded as Ankjit Surekha instead of Ankit Surekha. Accordingly, name of the counsel appearing for the Havana Municipal Corporation shall be read as Ankit Surekha.
Wait, please, Your Lordship. The last occasion, my lord, had directed the state to produce the case diary.
Yes.
Have come up for quashing of, my lord, a proceeding, a commercial proceeding, my lord, which has been given, my lord, criminal colors. Now, the charge sheet has been filed, my lord, alleging offences under section 420 and 406. My lord looks at the column for properties seized, nil. My lord, 406 will not lie, no properties have been seized. And my lord is a continuing business transaction. So, my lord, question of 420 will not rise. It is definitely a dispute, my lord. It's a commercial dispute, my lord.
Yes. You are appearing for the state.
My lord, I'm appearing for the state.
Yes.
My lord,
What is
documents were called for from the opposite party. He couldn't produce any documents. My lord, if your lordship turns to page 21, 22, and 23 of the case diary.
When the FIR was chalked out, madam? You are a copy? You are having the copy?
My lord, yes, my lord.
When the FIR is chalked out?
My lord, 13th of May 2022.
13th May?
Yes.
March?
May.
13th March? March or May?
May.
Is a May? I don't know. 13th May 2022. Correct. When your case diary opened? 13th May. So what has happened? I examined the complainant which is fully corroborated with the complaint. Did not recorded his statement and did not recorded his statement under section 161. Yes, which page you are relying? 21?
Page 21 to 23. My lord, before that, my lord, on page 13, your lordship would find the 91 notice.
Page?
13.
Yes.
Certain documents were called for from the opposite party number 2, who happens to be the complainant. My lord, if your lordship now turns to page 21 to 23.
So this notice was issued on 15th of May 2022.
Yes.
Correct. So she has not come forward after receipt of the notice.
My lord, he couldn't produce any documents is what is appearing from the case diary.
That's why Samiran is the complainant.
Yes.
You issued the notice under section 191 of the CRPC for production of the document.
Yes.
She had not turned up.
No. And that is reflected on page 21 to 23.
Just a minute. The notice was issued on 15 May. Prior to that, you issued the notice on 14 capital A to the accused.
After a reminder was also issued to the accused.
So what is your instruction?
Lord,
How 2022 FI was chalked out 2025. Nothing, no progress. Where is the document in the CD? No document.
Document, Lord.
So what is
charge
the
sheet was filed.
Huh?
And charge sheet was filed.
Where is the charge sheet?
Lord, page 26.
Huh?
Page 26.
26. Charge sheet filed. Where is the list of document?
My lord.
What document relied upon under 406?
Lord, no document could
No
be
document 406.
That is what is reflected in the charge sheet, my lord.
Who is the investigating officer? Call him. What is the post of the investigating officer? ASI. Assistant Sub Inspector. He is investigating or he is taking the help of the complainant. Kindly see the last paragraph. Last paragraph. During the investigation. Starts second paragraph. After the accused person surrender. Read loudly.
Lord, during the investigation of
Now
the case,
leave aside the middle portion. After the accused person surrendered.
After that accused person surrendered before the learned court respectively on 27th of January 2023, released on bail.
Yes.
I asked the complainant to produce more witnesses in this case, but till date he could not be able to produce.
The complainant will produce the witness or the investigating officer will do his business. Next. Go forward.
Lord,
In
I
this case,
also
but till date, could not able to produce any witnesses.
I also requested complainant to produce injury report and fever in connection with the above mentioned case reference for the purpose of
First line. That's funny. It's the first line. During investigation of the case, PO, place of occurrence was which is PO.
You are independently appearing in the matter for the state. You are appearing, yes. What is to be done with this type of the investigation? This type of the charge sheet. Complainant made a complaint 156.3. You initiated the FIR, nothing, and you file the charge sheet. If you are not having the evidence, what is the duty of the investigating officer?
He should have filed a final report.
Then sense offering for the petitioner, sense offering for the state. In terms of in compliance of the order passed by this court dated 20 March 2025, the state has produced, the learned advocate appearing for the state has produced the case diary. Counsel for the state submitted that the investigation has been completed and charge sheet is filed. This court has gone through the charge sheet. A charge sheet has been filed against the petitioners. Petitioners against the petitioner for the alleged offence under section 420/406 of the IPC. Correct. This court has gone through the charge sheet. After going through the charge sheet, this court find that the investigating officer in the charge sheet has recorded as follows. This paragraph. This I am keeping this. Is original, no copy. Page 28. This during this. Correct. That one, police. This court find that after receipt of this court find that this case has been initiated by the police of PS Kharda on the as per the order passed by the Learned, which court? By the London magistrate? By the Learned Additional Chief Judicial Magistrate Barakpur under section 156 within bracket 3 of the Code of Criminal Procedure. After initiation of the FIR, the investigating officer has issued notice under section 191 under section 91 of the Code of Criminal Procedure to the accused person, to the complainant. But the complainant has not come forward with any document in support of her claim. The investigating officer at the time of filing of the charge sheet has also stated that the complainant has not produced any witnesses. Even the complainant has not produced any injury report. This court failed to appreciate that the complainant has made the complaint before the magistrate under section 156 within bracket 3 of the Code of Criminal Procedure for initiation of the FIR, initiation of the case, and investigation of the matter. In terms of the prayer made by the complainant, the London magistrate has directed the concerned police to initiate the FIR and investigate. Accordingly, the police has investigated the matter. But it is found that, this could find that during the investigation, the police, the investigating officer did not find any material to corroborate the complaint made by the complainant in the petition. Only petition. The investigating officer has categorically stated that there is no witness, there is no document, and nothing has been produced by the complainant to support her case. But in spite of the same, the investigating officer has submitted the charge sheet. Considering the above, this court find that there is no case made out against the petitioner for the alleged offence under section 420/406 of the IPC. But in spite of the same, the investigating officer has submitted the charge sheet. The charge sheet which has been submitted by the investigating officer does not contain any document to prove that the petitioner has committed any offence. Considering the above, this court finds that this is the fifth case wherein the charge sheet filed by the charge sheet filed by the Kharda police station is required to be set aside. Accordingly, the same is set aside. The case initiated against the petitioner being, what is the case number?
Case number 4173.
Being GR case number 4173 of 2022, arising out of Kharda police station case number 376 of 2022, dated 13th May 2022, under section 420/406 of the Indian Penal Code, is set aside and quashed.
Should I kindly indicate that the photocopy of the case diary is being kept
The
with the record?
photocopy of the case diary produced by the state be kept with the record.
And I'm also
CRR number so and so is allowed.
thankful to my learned friend for his fairness. Grateful.
Next. Yes.
Madam, I'm appearing on behalf of respondent number 2.
State further order. Who is appearing for the state?
I'm for the state, Lord.
Yes. What is the stage of the case?
Lordship,
Investigation completed.
Lordship, I have to call for the case diary, Lordship. If your Lordship direct me to call for the case diary, I will call for the case diary.
Lordship, remember, this is a 136(3) application by virtue of an order passed wherein the FIR was initiated.
Correct.
But
They have to file the charge sheet or final report. Let case, if it is the same situation.
Lordship.
What is the case under section 420?
420.
And 304A.
304.
Why 420 304A?
Because the allegation is fake doctor.
Fake doctor.
Fake doctor.
Fake doctor is okay. Then 304. How the 304A?
He prescribed some medicine.
So how the 304? How the 304A will come? Or 303 313? Okay, whatever it may be.
Lordship, I do not know whether the charge sheet has been submitted or
So and so appearing for the petitioner. So and so appearing for the state. Full stop. Counsel for the state submitted. Prays for time to produce the case diary. Accordingly, the state is directed to produce the case diary on the next date fix. List the matter on 10th of April 2025. The affidavit of service filed by the petitioner be kept with the record. When your stay is going to be expired? 6 weeks.
it will be valid in the last week of April.
Last week of April. 13th March. Okay, last week of April. Yes, next.
Please, your lordships, my lord. My lord, on the last occasion, your lordships were pleased to, my lord, pass interim order, my lord, and directing the petitioner, my lord, to serve the opposite party, my lord.
Have you served?
We have, yes, my lord, and the my lord,
Who is
and my
appearing?
lord, it appears from the my lord track report, my lord, that it has been delivered to the address, my lord.
Item delivered.
Yes, my lord. Nobody is appearing for the white opposite party. There was some delay in uploading the order, my lord. Thereafter, it was mentioned before, lordship. Thereafter, it was uploaded. Immediately after the, my lord, it was uploaded. We have served, my lord. It's sent, my lord, and it has also been delivered upon
26 March. Today we are on 27.
Yes.
So it is where? Which place?
So that is
Rampurhat.
Yes.
Take time.
That is on the last, my lord. Yesterday it was, my lord.
Correct. So I am fixing next week.
After 10th April, my lord, the honorary is subject to lordship.
Again, you inform the date.
Yes.
So and so appearing for the petitioner. None appears on behalf of the opposite parties. Counsel for the petitioner has filed affidavit of service. Let the same be kept with the record. Police. It is fine from the affidavit of service. The notice has been served upon the opposite party. Number 2.
Yes, my lord.
2 only on 26th of March 2025. Accordingly, for the interest of justice, the case is adjourned. Let the matter appear on 17th.
My lord.
17th of April 2025. The petitioner is directed to communicate this order to the opposite party.
Only just order, my lord, because we have served the copy.
Communicate this.
Deep lord.
Item number 6.
But I beg to appear on behalf of the opposite party.
Yes.
And for the petitioner.
Your lordship will recollect.
You are for the petitioner. Yes.
Can we get a copy of it?
Yes. What is the case?
My lord, case under section 196, 299. Please tell. Apprise, my lord.
On the same cause of action, the FIR was lost against the petitioner, but she has deleted all these videos from her social media, and she got bail from the division bench also. Nothing has been.
Who got bail?
The petitioner.
Who are you?
She is the accused.
What is the section against you?
196.
299.
299 and 350.
Bharatiya Nyaya Sanhita. Yes. So, what is the ground for quashing?
Nothing has been proceeded, and she has deleted all this video, and she has not posted any kinds of video further.
Who?
The petitioner.
Correct. So, what you want? So, you have deleted the video, the criminal case is gone.
The investigation is still going on, Lordship. The charge sheet has yet not been submitted.
But only
investigation be complete.
But it was a privilege where we had appeared before the division bench of this honorable court. So the state had taken all the trouble to make a transcript of the video recording. Kindly have a look at what she has done. And this is not
after
just
this, she got the bail.
Right. You also see the observation. Bail is not a.
And the bail.
After the observation, she has not posted any.
It has been marked.
Neither is she has given any.
Please kindly have a look. Malad, kindly comes to internal page 5. Reach. And this has been since last 5 years. She has been continuously involved. She gets warnings from the honorable courts, but thereafter again she starts.
No, she has not posted or she has.
Okay, what is the stage of the investigation?
Interviews regarding this
going on.
Ah.
And my lord, the statements of the opposite parties have been recorded.
When the FIR was chalked out, madam?
FIR was lost 10th of
September.
September 2024.
Ah.
Lord, then the opposite parties were called for to give the pen drive
Ah.
containing those videos.
Ah.
Lord, that they have provided.
Ah.
Subsequently, they were requested.
Any 164 statement recorded?
161 statements are there.
Not 164.
No.
That has to be done.
Why?
Still, till now the FIR stage is investigation is in.
Correct. Investigation.
Nothing has been done yet.
Correct. That's why I'm asking. What is the stage of the investigation? Without the investigation, how the court can quash your? Let some material is to be seen. At the time of investigation, the court can interfere with.
Investigation is not proceeded.
So that's why I'm asking.
Lord,
where is your CD?
My lord, investigation is proceeding, my lord. If your lordship turns to page 23 and 24, it contains the statements under 161 in which the opposite parties have specifically stated that they couldn't provide the original URL, the original link for these videos. My lord, I have given it to your lordship, page 20.
Who will provide?
The original link to those videos were called for that they couldn't provide.
Who?
the opposite parties, the complainants.
So far as my client is concerned.
Madam, you are how the complainant will, what type the investigation is going on in Calcutta? In West Bengal, sorry.
Fail to understand, my lord, what type of submission is coming from the state?
URL, how she will provide? It is the investigating officer to find out from the net which URL it has come.
My lord, it's not there on the internet anymore.
What?
The videos.
My lord, may I? My lord, initially this accused was called in the police station. She was asked to give her details. Now immediately she said that I will remove that video. That could have been easily gathered from that. That means they are hand in gloves. They are trying to promote this lady. Till now, my lord, it has rightly fallen from my lord that 164 statement has not been recorded. I fail to understand, my lord, this is the case. My lord, 19.1 gives us the freedom of speech, but 19.2 at the same time, my lord, restricts. But the entire West Bengal, she has created disharmony amongst the irrespective of, my lord, caste, creed, and religion. What she is doing, my lord, she is making, my lordship sees the transcript, my lord, statement against Prophet Muhammad.
Madam, this URL is not on the desktop. It will not be. What is the duty of? Have you seized the where from it is in the mobile or in the computer?
No, they've given it in a pen drive.
Whether it is in mobile or it is in computer
That could not be a
or in the laptop. If it is a mobile, in whose mobile? In whose mobile?
No, that is not reflected in the statement.
Please
whose mobile this photo this has been exchanged?
From her mobile.
From the mobile of the accused?
That has not been seized?
That has not been seized.
That has not been seized. If it is not been seized, how you can ascertain? Mobile has to be seized, sent to the forensic. Can I teach the investigation sitting here?
Lordship, give us 7 days time, Lordship. We will clarify what the investigation will, how the investigation will go.
If you have not seized the mobile phone and he is telling that he has deleted, fairly in the open court he is telling that he has deleted, you will tag with the 201.
In different.
Yes, rightly fallen from a lord, and they are hand in gloves.
You will be in the 201 again as per
They
your
are trying to
submission.
protect this, giving shield.
Whether the petitioner did, but then and there she deleted it.
That's why. So if it is deleted, now what is the new section of the 201?
My lord may see the from the order of the bill application.
Sir, that is.
I'm so grateful. My lord, may I? If he, my lord, relies upon the application for bail.
Okay.
Yes,
You do one thing.
In this order copy, it has been stated that
Time, Lordship, next week, fix it next week. Lordship.
You instruct your investigating officer.
Lordship, I got it.
They have to.
And if it is come in my hand, then it will be difficult for the investigating officer, sir.
Lordship, give us 7 days time.
My lord,
We'll
only, my
file a
lord,
report.
sorry to trouble your lordship, paragraph 5, where the division bench has observed the petitioner's interviews contain grave insinuations against a religious community. We are conscious petitioner has freedom of speech. However, the freedom does not entitle her to incite hatred amongst communities, contrarian views with regard to relations between different religion communities and concept of secularism, a cherished basic structure of the Indian Constitution.
And nowadays this is going on.
And she's being, my lord, provoked, and she's being paid to do all these things. So far as state of West Bengal is concerned.
So and suffering for the petitioner. So and suffering for the opposite party number 1 state. And so suffering for the opposite party number 2 de facto complainant. Police counsel for the state press for a week time to produce the case diary. Accordingly, case is adjourned. Let the matter appear on 3rd.
My lord, I have. May. Okay, that's good.
The matter of
3rd, my lord, I will be in
okay,
Delhi.
10th of April 2025. The state is directed to produce the case diary on the date fixed.
Only one thing.
The affidavit of service.
My lord, till date kindly give a stay
by the petitioner be kept with the record.
What is it? He is asking for stay.
My lord, till date, my lord.
If I will stay, what the investigating officer will do?
Can they proceed? My lord, only one thing.
What the bail? So what investigation is not completed. So what is stay? Already it is stayed.
My lord, only one thing, my lord, subject to your lordship, my lord. My lord, your lordship will kindly observe. My lord, so far as, my lord, the
That's why I want to see, because they are not having the seat.
Only, my lord, direction upon them, my lord, to, my lord, record the 164 statement.
Let the CD come. Without
After
the
that.
CD, it is not.
And also to seize the mobile.
Come.
I'm so grateful, my lord. Deeply obliged.
Number 7 I dictate. 7 and 8 same, more or less same matter. Here what happened, my lord, the petitioner before your lordship is challenging them, my lord.
You are for the petitioner?
Lord, I am challenging them, my lord, the proceeding initiated by the opposite party, my lord, under section 12, 18, 19, 20 and 22 of the, my lord, domestic violence. Now, my lord, just certain dates, my lord, are necessary, my lord. I am just, my lord, pointing out to your lordship, the petitioner before your lordship is a husband. The marriage, my lord, took place on 2/7/2006. My lord, it was registered on 21st of July 2006. Thereafter, my lord, I have initiated
marriage 2006.
Now, my lord, I had initiated, my lord, divorce proceeding, my lord, on 23rd of October 2017.
After 11 years.
Yes. Thereafter, my lord,
Any issues?
No, one issue is there. Now, my lord, wife thereafter, my lord, file an application under section 24.
Correct.
24 of the Hindu Marriage Act. Thereafter, my lord, Lane district judge, my lord, passed an order of alimony penalty, 25,000 for the wife and 15,000 for the
in the
children.
divorce suit.
Yes.
Correct.
Now, yes. Now, 40,000 I have been paying. Now, ultimately, the matter went to the Supreme Court regarding this. Supreme Court, my lord, directed me, my lord, to go on paying. I have been paying it. Now, my lord, it is an admitted fact, my lord, 2019, she left the maternal house. So, 2017, she left the maternal. After near about, my lord, 8 years, 7 years. Now, this complaint was, Lord, kindly take the impugned, my lord, complaint. My lord, I just show to your lordship, my lord, 2 paragraphs. Kindly take the, my lord, certified copy. That is, my lord, paragraph 21. It is, my lord, inert page 13 of the certified copy. Now, my lord, paragraph 21 says.
Inert page 13?
1-3.
Yes.
At the top, my lord, you will also get it. Paragraph 21.
21, yes.
Yes. It says, my lord, this is her admission. It was ever since 29th of November 2007. The petitioner and the opposite party started living separately and from each other, and after such separation, there had been no occasions for cohabitation between them. The petitioner all along had tried to reconcile, and accordingly, in consultation and assistance of the relatives, tried to erase the dispute and the differences between themselves. But however, the cruelty inflicted upon the petitioner by the opposite party and his representative found no pause. Now, my lord, kindly text, my lord, paragraph, my lord, 30, next page. Next page, paragraph, inner page 14.
Yes.
Paragraph 30.
Yes.
The cause of action arose on diverse dates, lastly on 29th of July 2017 at such and such, and the petitioner is presently residing at tower number such and such, police station.
When this case is filed?
Well, case is filed, my lord, it is filed on, my lord, 12th of September 2024. No, my lord, but there must be a limit.
7 years.
After 7 years, may serve and come back, my lord.
No, this limitation is applicable.
My lord, I will argue to that effect. My lord, this is a quasi-civil in nature. My lord, even if the revelation...
I think there is a judgment of the Supreme Court in the limitation point. It is
that is, my lord, in respect of 468.
No. So, lodging
of complaint. I have to check it. My lord, I'll check it. But there, my lord,
it was the Karnataka. Then it was went to the Supreme Court, because last 3 years I am not dealing with
I'll check. I will check.
Just find that 2000 initially when this act was commenced, this matter, this point was arose, and it went up to the Supreme Court.
I'll check.
I could not remember. Please take it.
Yes.
What is the stage?
Well, the next date is fixed on, my lord. Just notice was issued 9th most probably.
So and so applying for the petitioner. The petitioner has challenged the proceeding initiated by the opposite party number 2.
Opposite party.
Only
one.
Number 1. Why?
Party. Only
Against
opposite
the petitioner for the against the petitioner under the Protection of Women from Domestic Violence Act 2015. It is found from the record that in paragraph 30 comma, the petitioner has stated the opposite party number 1.
Only opposite party, my lord.
Huh?
Only opposite party.
The opposite party stated that the cause of action arose on diverse dates, lastly on 29th of November 2017. Full stop. If full stop, the counsel for the petitioner submits that prior to lodging of the present application, comma, the petitioner has initiated a matrimonial suit before the Learned Court of
Before the Learned District Judge Alipur.
Before the Learned District Judge Alipur. In this said case, the opposite party has filed an application under Section 24 of the Hindu Marriage Act, and in the said application, comma, the Learned District Judge
Barasat.
District Judge Barasat had passed an order for grant of maintenance pendant light for a sum of rupees 20,000 each.
25,000 for the wife and 15,000 for the
opposite party and 15,000
for the child.
For the child. Full stop. Counsel for the petition submit that the petition is paying the said amount regularly.
Yes.
Full stop. Considering the above, this court find that the petitioner has made out an arguable case. Accordingly, for the time being, the proceeding initiated by the opposite party number 1 against the petitioner being complaint case number 2807 of 2024 under section 12, 18, 19, 20, 22, read with section 23 of the Protection of Women from Domestic Violence Act 2015, pending before the Learned Judicial Magistrate, 10th Court, Alipur, South Parganas, is stayed for a period of 6 weeks from date. Full stop. The petitioner is directed to issue notice upon the opposite party and to file the affidavit of service on the next date fixed. This is the matter on 10th of April 2025. Next.
Item number 9.
7, 8. 8
also.
But 8 is there. 8. So far as 8 is concerned, petitioner number 1 is the brother-in-law, and petitioner number 2 is
another case.
Same case.
Same case.
Same case. 3 persons have been implicated as a party: husband, brother-in-law, and sister-in-law. Here, only petitioner number 1 is the brother-in-law, and petitioner number 2 is the sister-in-law.
In the cost title, the both number may be given. Then one single order. Case number is same.
Case number same.
Only the case in both.
Item number 9.
Well, deeply obliged.
May it please your lordship, my lord. I'm for the petitioner, my lord. But this petitioner has come with your lordship, my lord, challenging the entire proceeding, the FIR, the charge sheet, and all the orders passed therein. Now, a very short point, my lord, in this matter. My lord, the case was registered under section 376, 417, 420. But at the very outset, my lord, I will trouble your lordship to, my lord, kindly comes to the written complaint, which your lordship will find at page 26, my lord. But your lordship might face some difficulty because it is in Bengali. Now, my lord, I will trouble your lordship to kindly comes to page 30, which has been recorded in English. Kindly comes to page 30, my lord. Your lordship will find that paragraph 17, brief fact of the cases. Has your lordship got it, my lord? Yes. Page 30. But the fact of the case in brief is that received a written complaint from the victim lady, such and such, against one Lakshman Mondal, being the petitioner, my lord, herein, to the effect that since last 4 years, one Lakshman Mondal used to come to my complainant's house, and several times he made sexual intercourse with the complainant, giving her false pledge of marriage. Now, when the complainant asked the alleged person to marry her, he refused to do so. But pausing for a moment, as your lordship is aware of, there is a judgment of the Supreme Court, Apex Court. Promise to marry cannot be a false promise. So, my lord, straight away 420 goes. There cannot be any cheating. And so far as, my lord, your lordship takes the last paragraph, my lord. So far, investigation proceeded, it's learned that Lakshman Mondal is held responsible for prosecution under such and such as indulging in consensual. So, my lord, with deepest respect, my lord, the question of 376 does not come. It was a love and affair relationship, my lord, from where, and she being a major, my lord, the
What is the stage of investigation?
For fixed for appearance on, I have got the exact date, 17th of June 2025.
Charge sheet filed.
Charge sheet has been filed. I've annexed the entire documents, 207 papers. Now, if your lordship takes the statements also, everyone is saying, my lord, they were, my lord, kindly, I'll trouble that part only just few lines. 37, my lord, kindly comes. I'll read it in Bengali, my lord, and I will explain. Kindly comes to page 37. They are all interested witness. I'm just reading it out. আপনার থানায় জানাইতে গত সালে জুলাই মাসের আমার মায়ের মৃত্যুর পর আমার সাক্ষ্যে লক্ষণ মণ্ডলের সাথে পরিচয় হয়। তারপর আমরা প্রায়ই কথা বলতাম এবং আস্তে আস্তে আমাদের মধ্যে ভাব ভালোবাসা মিন্স লাভ অ্যাফেয়ার সম্পর্ক গড়ে ওঠে। এরপর গত 28/7/2020 তারিখে লক্ষণ আমাকে জানায় যে ও আমাকে
নোটিস জুন ইট ইজ না issue notice.
Kindly, I'm praying for stay with the other.
June is there. June
Yes.
is there.
I would not have trouble if this would not have any merit, my lord. Your lordship knows.
Correct. Let the CD come. Let the CD.
Some satisfaction because we have to, my lord.
Let come. So appearing for the petitioner. The petitioner has filed the present application, praying for quashing of the proceeding of the sessions case number 149 of 2024 arising out of Haringata Police Station case number 155/2024 dated 21st of March 2024, as well as the charge sheet being charge sheet number 251 of 2024 dated 31st of May 2024 under section 376, 470, 420 of the IPC. Full stop. Counsel for the petition submitted. The police has already submitted charge sheet and the next date is fixed in the month of June for appearance of the petitioner. Full stop. Considering the above, this court find it before passing any order. Before passing on any order, the court intends to go through the case diary. Accordingly, the state is directed to produce the case diary on the next date fix. The petition is directed to serve the notice upon the opposite parties and to file the affidavit of service on the next date fix. Let the matter appear on 17th April.
I'm so grateful, my lord. I'm deeply obliged.
Speed.
Well, only one thing, your lordship, at the time when I come back before your lordship, that time, my lord, I should have a liberty, my lord, to pray for an interim order.
That I am not decided. That's why. Yes.
I'm so grateful. Deeply obliged.
After lunch, before lunch, you do.
This is supplementary affidavit pursuant to filing of this revisional application. I was supplied with copy under section 207 CRPC. This contains the copy of police report. Now, petitioners before your lordships are
application
seeking quashing on behalf of the parents-in-law who are aged about 74 years and 62 years respectively. My lord, if your lordship kindly come to the impugn FIR, that is at page 23.
All in Bangla language.
My lord, I will read, my lord.
What you will read?
I will read. Not even I am.
I can't read anything.
My lord, what? My lord, your lordship permit me to read, my lord.
What is that? 498/307?
Yes, this was started and ultimately.
307?
No. When 307 was alleged, at the time of investigation, police didn't find anything with respect to 307 and charges submitted only under section 498/34.
Against?
That your lord. Against everybody, because all were named. Husband, father-in-law, mother-in-law. Husband is an army, is working there. The evidences of witnesses are there. They have specifically stated whenever he goes, she used to leave the house of the parents-in-law, used to reside with the with her parents. Even her parents have admitted so. Lordship kindly come to page number 24, the charge sheet. First, I will say that this is not a case under section 307.
24.
24, my lord.
Supplementary.
Lordship, the main application.
Yes.
Your lordship is getting charge sheeted section 498/34 only.
Correct.
Now, my lord, why 307 was not filed? My lord, we file explanation with respect to that at page number 35.
Okay, no problem. 307 is not there.
Nothing
not there.
there. So, my lord, I was beseeching before your lordship that these particular persons who are senior citizen before your lordships have been falsely implicated in the particular case. Why?
because her first allegation with respect to 307 was particularly related to a particular incident, and that was unrelied by the investigating agency itself. And if that part goes, then my lord, the perusal of the FIR will show that there is nothing specific allegation against this particular petitioner in the impugned FIR. Now, my lord, permit me to read FIR, and also, my lord, that particular lady.
Come to charge sheet 26. That
23, my lord. Nivedan A, je Amar Sahit.
During the investigation.
During the investigation, lordship, that
your lordship will the complainant visited the PO, prepared the rough sketch map with it index and so and so.
I seized the original marriage certificate under proper seizure list signed by witnesses. I tried to collect injury report of the injured Rakhi Mandal, but she stated that she cannot provide her injury report as she never treated her injuries. FIR was filed after 3 months of the incidents. I recorded a statement under section 161 CRPC. I held raid at the house of FIR named accused person, but during raid found them absent from their house. I contacted my reliable sources to collect information of the accused person in connection with the case, but in vain. FIR named accused person such and such surrendered before the court Malda and released on bail on such and such date. FIR named accused person, namely Mithu Mandal, son of such and such, Malda surrendered before and released on court bail. During investigation, a prima facie charge has been well established under section 490-34, read with 3 and 4 of the dowry provision. Nothing.
Where is the list of witness?
My lord, that I have annexed in my supplementary affidavit. If your lordship permit me to read, starting from page number 7 onwards. That is the statement of the victim herself. My lord, may I permitted to read from 8?
9 witnesses.
My lord.
9 witnesses. One is the complainant.
Complainant.
Another is
Krishna Mandal, who is the neighbor. My lord, just permit me to read, my lord. This is very important. My lord, 4th line, your lordship may come. 4th line of page number 8.
Page number 8.
8. My lord, I am reading, my lord. Mithun Mandal, my lord, that is the husband of the lady. একজন আর্মি পুলিশ বেশিরভাগ সময় কর্মসূত্রে বাইরে থাকতো রাখি মন্ডল is the complaint. রাখি মন্ডল সেই সময় এখানে থাকতো না. Now this is clear that she doesn't used to reside there. Now my lord, may again come last but single line. Second line. উত্তেজিত হয়ে মিথুন মন্ডল তাকে চড় থপ্পড় মারে. Now even that is not related to this persons before your lordship. সেই কারণে রাগ করে রাখি মন্ডল তার স্বামীর বাড়ি থেকে বেরিয়ে যায়, সে এখন তার বাবার বাড়িতে আছে। Now my lord, she never resided with these persons and they have been implicated. Again I will show another witness, my lord, page 9, 4th line. বেশিরভাগ সময় কর্মসূত্রে বাইরে থাকতো হাজবেন্ড, রাখি মন্ডল সেই সময় এখানে থাকতো না।
এখানে থাকতাম মাদার্স
parents in law. Now my lord, parents in law are before your lordship. Now my lord, whenever husband is not here, she used to leave the house. She resided with her parents. Now, my lord, every family members have been implicated. And this particular practice has been deprecated by Honorable Apex Court in series of judgment. I will just place 2.
When is the date fixed? Next date?
My charge sheet is submitted. They are being harassed. They are regularly called before the court. My lord, pro husband, I am not before your lordship. Because there is a specific allegation against husband. I am not for the husband, but for the parents-in-law. My lord, they are unnecessary.
When is the next date fixed?
My lord, 28th of April.
Okay, issue notice.
But stay in the meantime because charge will be framed.
That's why I'm asking, when is the date?
28th of April, I have said, my lord.
When do you take the date? I will not.
But fix prior to that. My lord, fix prior
yes,
to
I am fixing prior to that. 28th.
So with liberty to pray for step not taken for hearing.
Petitioner, the petitioner has filed an application. Filed the present application, praying for quashing of the proceeding initiated by the police of English Bazaar Women Police Station, being PS case number 15 of 2022, dated 24th January 2022, under section 498A/307/34 of the IPC, read with section 3 and 4 of the Dowry Prohibition Act 1961. Along with the charge sheet being number 233 of 2023, dated 31st.
But only one thing, if your lordship don't take me amiss. One English complaint is there at page 28.
Under section 498A/34 of the IPC, pending before the London Court of.
Page 28 of main application.
Now, which court? London Court of Chief Judicial Magistrate.
my lord, the main revisional application, she has
No,
filed.
the applicant, this case where the case is pending.
My lord, CGM Malda.
Chief Judicial Magistrate Malda. Malda. Consider the submission made by the counsel for the petitioner. The petition is directed to serve the copy of the application along with all the documents as well as the supplementary affidavit to the opposite parties. And to file the affidavit of service on the returnable date. List the matter.
My lord, kindly come to page 28 once.
On 17th of April 2025.
Page 28, my lord.
17th.
Same lady with respect
page
to
number?
page 28 of my main revisional application. Your lordship, just kindly go through this, my lord. Your lordship will be finding not a single line as person.
28.
28, my lord.
Yes.
Your lordship is getting one English complaint. By same lady to my son's working place. Kindly see the complaint, my lord.
Okay, come on.
Not a single allegation,
One
my lord.
thing, if you able come with a translated copy, that will be
That I will bring. My lord, liberty
with the
to pray for stay if not taken by that time, my lord.
I am fixed at 17.
Under the same heading, my lord.
Same heading.
Deeply obliged, lordship.
Next.
Wait, please, your lordship, my lord. This is for quashing of a proceeding against my lord the sister-in-law and the my lord husband of the my lord opposite party number 2 wife, my lord. So I have prayed for quashing of the entire proceeding on the premises, my lord. After 16 years of marriage, my lord, 17B petition was pending between the husband and the wife, my lord. 13B petition was pending before the my lord learned district judge, my lord. During that period, my lord, even I was married before 10 years, my lord. And my lord, stray allegations, my lord, FIR, my lord, kindly have a look at the FIR, my lord. That a cause of action, my lord, that is, my lord, at page 41, my lord. My lord, what are the allegation against me? That I first day of June 2017 at the last night, both my father-in-law and
41?
husband, my lord, 41, my lord. Kindly have a look at the page 41, FIR, my lord. I am studying for 41. First day of June 2017 at the night, both the father-in-law and the husband under influence of liquor and the provocation of sister-in-law and her husband abused me and physically assaulted me. No injury report or no report is there, my lord. Now then, my lord, next, my lord, paragraph, my lord, kindly have a look. My lord, no GD entry, nothing, no complaint was whatsoever made. And, my lord, again, my lord, for the purpose of, my lord, attracting the provisions of 490 last on 22nd May 2022 at about 11 a.m. My husband, along with my father-in-law, sister-in-law, nonod, husband came to my paternal house. Lord, they have gone to the paternal house and tried to take my minor child from the custody, and on protest, all of them became furious and abused me with filthy languages, my lord. Lord, this is the, my lord, allegation against, my lord, the my lord, against the, my lord, sister-in-law and the husband of, my lord, the my husband.
So what is the section?
My lord, under section 498A, 406, and my lord also.
How the 406?
354.
What the 406?
Yes, my lord. So far my part is concerned, there is no offense, my lord. And now, my lord, interestingly, my lord, kindly have a look at, my lord, the framing of charges, my lord. Kindly have a look at. Interesting, my lord. How the, my lord, last part, my lord, the one page, my lord. Mechanically, my lord, charge has been framed, my lord, against all the sections against me and my husband. Last part 4, my lord.
Yes.
Against, my lord, together, my lord, you charge so and so. Your lordship got it, my lord. Lordship got it. My lord, who hereby charge you Alok Devnath, Yashwant Devnath, Payal Devnath, my client, and Amulya Devnath is follows. Firstly, so and 498A, 406. But how the 406 lies against me, my lord? No allegation whatsoever is against me, my lord. And whatever allegation was made against the husband, my lord, he has been returned, my lord. And so far 506 and my lord 354, my lord, I do not know how against a lady 354 lies, my lord. And my lord, fifthly, my lord, that 504. So this is the, my lord, the charge frame mechanically, my lord, and on the basis of, my lord, and the 13B apartment, my lord, kindly have a look at page 33, my lord. During pendency of that, my lord, 13B apartments, my lord. Page, my lord, 35, my lord, kindly have a look at page 35. That the petitioners state that, page 35, lordship got it?
Yes.
that they are not in a position to live and stay together. Well, I'm not the husband, and that they have been residing separately from 16/4/2016. So, the allegation, stray allegations, I'm a married sister-in-law. I'm residing elsewhere along with my husband. So, now kindly have, 13B is pending. 13B, so, on mutual consent.
What has happened to the 13B? 13B is filed in the 2021.
Thereafter, kindly have a look. It has been, there was some bargaining on settlement that has been dismissed.
Dismissed?
Yes. Kindly have a look.
She did not appear.
She did not appear. So, I do not know, even the after initiation of the FIR, But kindly see, what are the allegations, stereotype, mechanical.
Petitioner is absent. Which petitioner is absent?
Joint petition,
No, on that day, both have not appeared.
No, the petitioner appeared.
But in the order says petitioner, which petitioner?
Petitioner
one is the
number
wife.
one.
But
Mritika.
it is not mentioned in the order.
Petition number 1, that is. So, I am not concerned with husband, I am concerned with my sister, married sister-in-law, and the husband of the sister-in-law.
The petitioner before this court.
Petitioner, kindly have a look at,
File day.
Yes, sister-in-law, and his husband, and her husband.
And her husband.
Yes. Stray allegations, and the charge has been framed mechanically, and even the 354 has been against me. And 406. No allegation against me about the misappropriation of money. While framing, even I have challenged the framing of the
charge is last but one page, which you read, na?
Yes.
Where is the name of the accused persons?
Yes, kindly have a look at, that Hooghly, I hereby charge you, Alok Devnath, Subhonath De, Sushobhan De, Pile De. Pile De is petitioner before Lordship.
Which page you are reading?
The last but one page,
Last but one page.
Yes, kindly have a look.
This one.
Yes, that is there, May I point out, kindly have a look it.
Page number 14.
Page number may not be there. Mechanically, both the persons, that are there, and same charges. And on the basis of which, I do not know, there will be absolutely abuse of the process of if the child trial is held on the basis thereof.
Charge you Alok Devnath, Sushman Devnath.
Yes, but
Alok Devnath is the?
Alok Devnath is the husband. I am not for husband. Pile Devnath and Amulya Devnath.
And
Here,
what?
here.
Amulya Devnath.
Yes.
And who is the other?
Pile Devnath and
Alok and
Pile Devnath and Sushobhan.
And who is the Amulya?
Amulya is the father-in-law. I am not father-in-law. Married sister-in-law and her husband. 1 and 2. Pile and Sushobhan Dev. Sushobhan Dev. What are even the FIR, no ingredients of that, any stray allegations, cannot be a ground under the mechanically charge.
Next date. When is the next date fixed?
Today was the date fixed. That was yesterday it was mentioned before your lordship, on the basis of that it was upgraded,
So when is the date fixed?
Today was the date fixed, We have prayed for adjournment on the
Sir, what date you got now?
Tomorrow.
So, kindly stay the proceeding, kindly. Yes, because the stay, trial will continue, So far as against the two persons, your lordship is prima facie satisfied, there are no ingredients of the mechanical with the charge has been framed. On the basis of the charge, if the trial proceeds, there will be a gross abuse of the process of law. Kindly, see, joint charges, Pile De and Sushobhan De. 354 is also against me. 406 is against me.
I don't think by April it is fixed. I am fixing in the month of April.
Yes, kindly grant a short stay so far as those two petitioners are concerned.
Two petitioners, then the total proceeding will be.
Yes, because that should be, kindly consider this should be, because kindly fix up a short date, let them come up. In the meantime, let there be stay, for a limited period,
So and so suffering for the petitioner. The petitioner has filed the present application for quashing of the proceeding in respect of GR case number in respect of the petitioner's herein in connection with GR case number 1230 of 2022 arising out of Sri Rampur Women Police Station case number 38 of 2022 under section 498A/354B/406/504/506/34 of the IPC.
354 also,
Yes.
Against the lady, my lord,
Pending before the
354.
landed Chief Justice Magistrate, Third Court, Sri Rampur, Hooghly. Considering the submission made by the counsel for the petitioner, the petition is directed to serve the copy of the present application along with the documents to the opposite parties and to file the affidavit of service on the next date fix. List the matter on 17th July, 17th April.
17th April.
Yes.
May I resume my prayer for stay, my lord? Because, my lord,
Yes, because
it is
let
a
me
feat
see.
case, my lord. Kindly, my lord, see, my
Let
lord.
the state come.
Yes.
Not today. Next.
13, my lord, I am for the petition. 13 and 14 both are. 13, my lord, I am paying for the quashing of the order passed by the London Additional District and Session Judge.
Have you served the copy?
Yes, yes. Sir, copy, sir.
You are appearing for state or opposite party?
Opposite. Now, my lord, my case is, my lord,
What is the case under section?
under section 125. 125.
Any
My
order?
lord, the marriage was took place on 21st.
Where is the order? Where is the order?
My lord, order is, my lord, last.
Second division, my lord. Second division.
Before the district judge, session
Yes,
judge.
yes.
Yes.
Affirm the order of the
From the order of the
Affirm, my lord, 10,000 order was passed 10,000. It has been decreased 7,000.
Initially,
spite
it
of that,
was
my lord,
10,000 by the London
in spite of that, he has come.
I
before the law.
filed a revision whereby the order was 7,000.
Yes.
My only grievance is whether both the court below directed my client to pay the maintenance amount from the date of filing of the application.
Yes.
But your lordship kindly direct me below to file the date of.
Still now amount has not been paid.
That is
Yes,
my.
my lord.
I am praying.
See, that is the discretion of the London court. Discretion cannot be challenged under the revisional application.
The maintenance in respect of my daughter. I am ready to pay my daughter.
Why not wife?
But wife is service below. Is a school
Only for the daughter.
Only for the.
So,
only brother, I am কি কাজ করি আমি সহায়ক
50,000.
I am working
More
as
than
a
15.
panchayat সহায়ক. It's a limited income. Your lordship knows very well.
what the wife is doing?
Why is he teacher brother?
Head teacher.
In a high school tree.
Only 7,000 amount has been.
He's a head teacher of the school.
Correct.
No, he's not head teacher. No, not head teacher.
Okay, whatever teacher or not, whatever it may be.
Her liability below to maintain
Correct.
the
What is the age of the child? What is the age of the child?
7 years. Only 7 years.
School fees and other expenses, my lord.
School
Now a
fees,
7 days. He
studied in a
going to
remote
English
village.
medium, my lord. More than 10,000,
In a remote
20,000
village in a Bengali
expenses, my
village.
lord.
Your
Not
lordship
amount
kindly
paid.
appreciate.
2-time revision. Thereafter, I have come before your lordship, my lord, and challenging the no. I will not.
Sam,
I have stated in my petition, I am not suffering.
No,
any
data
harm.
until analysis, data filing. How
I am
they
not
will serve
suffering
my.
anything.
for the minor child,
No, but I am
7,000.
ready to pay. From the, because below some area was due. I am
Yes,
regularly.
amount
I
has
am
not
paying
been paid,
the
my
current rate.
not paid.
Regularly,
Still
I am
no.
paying the
No.
current rate. Area was due. That is for the date of filing of the application. That is why the area.
And also, my lord, execution.
You paid.
Challenging the execution proceeding. Also, my lord, two version 13 and 14.
Only your lordship kindly direct my client to pay the from the date of filing
No,
of
my
the
lord.
date of
No.
filing of the order.
Data filing, my
passing of
lord,
the
I am
order.
paying
If
for
you want, I will give the direction in the installment that I can do. Otherwise, nothing. I can.
Your lordship kindly allow the quantum.
What is the area spending? What is the total area spending?
5 lakhs. 5 lakhs.
5 lakhs 60,000.
5 lakhs 60,000.
Because when it is
5 lakhs
date of filing
60,000.
of the application, that is why the area.
5,60,000 and per month 7,000.
Yes,
Per
7,000.
month 7,000. So
That
5,
is paying, madam.
so 5 lakh you pay in the 5 installment and 7,000 you pay regularly.
Instead of 5 minutes lost.
3 months. 3 installment. 3.
Swaya
Huge
কত
money.
মাইনে পায় বলতো?
Cultivation is there. So
Teacher
many
কত
people.
মাইনে
So many amount.
70,000 টাকা টিচারের
No, for only 25,000. The assistant teacher.
মানে লসিপ কাইলি humble submission before lordship kindly quantum the
Sorry, that I will not.
instead of 5 your lordship
Well,
keep
kindly,
some time.
kindly,
But I am
consider
urging only
submission.
22
10,000.
5 lakhs. 5 lakhs. 5 lakhs. What is the total amount you are having calculation? What is the total till today?
So, my lord, that is my lord for execution today. Execution today. My next match is for execution.
Yes, what is the total amount claimed?
5,67,000. My lord, 5,67,000 since December 2017 to August 2025.
Okay, you pay
24,
you pay in five installment of 5,60,000.
Instead of 5.
No, 5
5
lakhs.
7. Your lordship.
No.
But I'm
5
paying-
and it starts from today. We are on
Today we have 27.
21st. Start from the 1st April.
And instead of 1st, you also kindly make it.
Okay,
1st
4th
May.
April.
1st May.
No. Sorry.
What is
Kindly appreciate. I am.
No bargaining.
Yes.
I am my lord. Only
সহায়তা
20,000
করতে হবে।
I am happy.
ওই জন্য তো সহায়তা করতে হবে।
Where is the order of the London magistrate?
My lord.
Where is the order of the magistrate?
Order of the magistrate, my lord, in
So and so appearing for the petitioner. So and so appearing for the opposite party.
page 20. It starts from
Opposite
page
party.
20 order of magistrate.
Opposite party number 1. Police. The
Page
petitioner
20.
has filed the present application.
execution.
Praying for quashing of
Ordering portion is page
for quashing
internal
of
17,
the impugn judgment
running
and
page
order
37.
passed by the London Additional Session Judge at Raghunathpur, District Purulia, dated 31st of August 2024, in criminal revision number 11 of 2024, wherein the London Additional Session Judge modified the order dated 15th March 2024, passed by the London Judicial Magistrate, 2nd Court, Raghunathpur, in connection with Miss Case number 84 of 2017, and directed the petitioner to pay the maintenance amount of rupees 7,000 per month from the date of filing of the application under section 125 of the CRPC. Police. Counsel for the petitioner submit that. Counsel for the petitioner submits that. Counsel for the petitioner submits that the London magistrate, by an order dated
15th
15th March 2024, has directed the petitioner to pay the maintenance amount of rupees 10,000 per month for the minor child through her mother, Sumitra Hansa, H-A-N-S Hansda, from the date of filing of the said case. Being agreed with the said order of the London magistrate, the petitioner has preferred a criminal revision before the London Additional Session Judge, Raghunathpur, Purulia, and the London Additional Session Judge, by a judgment dated 31st of August 2024, has disposed of the said revisional application by modifying the impugn order dated 15th of March 2024, passed by the London Judicial Magistrate, 2nd Court, Raghunathpur, by directing the petitioner to pay the maintenance amount of rupees 7,000 in favor of the minor daughter or son? Minor daughter, through her mother, within 7th of each succeeding month, instead of rupees 10,000. Police. Counsel for the petitioner submitted that the wife of the petitioner is also government servant and is getting more salary than the petitioner, and as such,
No, 25.
much more salary than the petitioner.
More less.
What is the
More salary than the petitioner, and praised for modifying the order passed by the London District Judge as well as the London Magistrate, by directing the petitioner to pay the maintenance from the date of order instead of the date of application. Full stop. Counsel for the petitioner further submitted the petitioner has also the opposite party has also initiated the execution proceeding, claiming the arrears of maintenance of rupees 5,60,000.
67,000.
5,67,000
Up to August 24. Up to August 24.
up to the month of August 2024. Up to the month of August 2024. Full stop. Subparagraph. Learned counsel for the opposite party raised objection. Submit that this is the second revisional application filed by the petitioner. He submit that being agreed with the order passed by the London magistrate, the petitioner has preferred the first revisional application before the London additional session judge Raghunathpur, and the London judge has already modified the order by reducing the maintenance amount of the minor daughter from rupees 10,000 to rupees 7,000, and as such, the order passed by the London district additional session judge is not required for any interference. Full stop. Considering the submission made by the counsel for the petitioner, counsel for the respective parties, this court find that the London additional session judge, considering the facts and circumstances of the matter, has modified the order passed by the London magistrate by reducing the maintenance amount of the minor daughter from rupees 10,000 to 7,000, and as such, this court did not find any infirmity in the order passed by the London additional session judge. Interfere with the London additional session judge. Accordingly, the revisional application is dismissed. Full stop. The opposite party has already initiated the proceeding for execution proceeding for recovery of the arrears of maintenance amount amounting to rupees 5,67,000 up till the month of August 2024. Up till the month of August 2024. Considering the above, this court directed the petitioner to pay the arrears of maintenance till the month of arrears of maintenance of rupees 5,67,000 in 5 equal installment.
But instead of 5, kindly
5
make it
equal
6.
installment
From
from
I'm paying for 4.
installment from the month of April 2025, and the first installment shall be paid on 7th of April 2025 and continuously, and the petitioner is directed to pay continuously till the realization of the total arrears, and the petitioner is further directed also to continue to pay the monthly maintenance without fail.
I'm paying.
CRR number 7 is disposed of.
I am.
14 is
Execution proceeding. Not maintainable.
Execution.
That is not maintainable. Withdraw kore ni.
Execution withdraw.
Yes.
I already passed an order.
Very well.
Which order?
I am withdrawing.
कौन सा उधर दूसरा मैटर
हमने तो जाने
record an order 14 in view of the order passed in CRR 4828 of 2024 the present application being CRR 4829 of 2024 is become infructuous, according dismissed.
I'm good.
Service be kept on
Yep.
I have already come.
Affidavit of service filed by the petitioner be kept.
Lordship, with your lordship's permission.
Come next.
Lordship,